Yes.
My lord, extension of interim order. Today is the last day, but what has happened, my lord? My connected appeal, my lord, item number 11, my lord. My lord, pursuant to the order of this court, my lord, all the appeal, my lord, tagged. But my matter not in the list, my lord, along with item number 11, my lord, 11, 12, 13, all, my lord, today is the last day for extension. Same prayer, bro.
Same prayer for.
Similar matter, you ought to have reminded us earlier.
My lord,
You
all the matter tagged, my lord, for
No.
every day, every occasion, my lord.
Had it been tagged, then my court officer would have
That's
mentioned.
only simultaneous.
You do not mention in time.
My lord,
They can now to listed.
Similar prayer, my lord.
11 এর পরে এটা উঠুক 11 এর সঙ্গে
দেখে দেবে ফাইল যদি আসে তাহলে
Files are all here in the court.
Pardon?
Files are all here in the court.
We do not know that. Hand over how many matters?
And one is in the monthly list, another is not in the list.
Monthly list which item?
223,
223.
Lordship.
220. Who is your other side?
My lord, the other, Mr. Shamik Chatterjee and Mr. Vivekananda Ghosh.
Have you given notice to them?
And I'll give the notice. My lord, the
So,
similar
I don't understand why did you come earlier?
similar matters are, my lord, listed as item number 11 to 14.
We 222 ওটাকে extension of interim order রেখেছে।
আমারটা লিখতে নেই
Yes. Don't mention. Today is not the mentioning day, Mr. Yes, call the list.
my lord
Today is not the mentioning day. Don't disturb. Yes, call the list.
মনে করছি না এটা জোড়া হলো কেন এর সঙ্গে
এমনি পড়ে রয়েছে ওরা লিস্টে
এর সঙ্গে tag হয়েছে এরকম একটা
সাথেই ছিল।
Lordship, I am appearing on behalf of the petitioner in this matter.
in both the matters.
Yes, in one, item number 1.
Yes, tell us. What is the matter? Tell us.
It is a habeas corpus, Your Lordship. In item number 1, there is a complaint that 13 persons were missing. The state has already given the report. The state has already submitted a report that out of 13, 9 has recovered and 4 are still missing.
You are appearing for whom?
For the petitioner, Prasenjit
Why
Mandal.
didn't you, when the matter last time, it is from 2019, you people are not appearing.
Yes, Your Lordship, actually the petitioner has, due to some personal difficulty, has taken the brief from me on
So
taking instructions from the person against, on behalf of whom the complaint has been made. Since the matter was pending,
here one Prosenjit Mondol
Yes, yes.
appeared in person.
yes, Your Lordship.
Have you filed your
Yes,
wakalatnama?
yes, Your Lordship.
What is your name?
Pooja Beriwal.
Very good. So what is your instruction now?
Instruction is that 4 persons are still missing and they had not been recovered till date.
When did you get such instruction?
It is yesterday, Your Lordship. I have already given the letter to the learned advocate appearing on behalf of the state that the matter is also pending
When have you given that?
on the 10th of August.
10th of August.
Yes, Your Lordship.
Who is the other side?
Mr. Sabir Ahmed.
Sabiram. Give a further notice, come up on 12th September.
Much obliged.
Yes.
You not today করে দেওয়া ভালো নাকি?
এদিনকে অ্যাপিয়ার করেছিল, কেউ আসে বিশেষ করে
আগের দিন কি বলতো একটা
কি হয়েছিল আগের দিন?
আগের দিন কি হয়েছিল? মিছিল অ্যাডভোকেট ছিল, অ্যাডভোকেট ছিল।
I am for the
Huh?
I am for the petitioner.
Fourth. Who is your other side?
Your Lordship, I'm for item number 3.
See already not today.
No, no, no. I'm
He
for
has been
state.
adjourned for the day.
Adjourned for that. Okay.
Come
Great,
tomorrow.
Your Lordship.
I unconditionally apologize. I'm appearing with the glasses since I got conjunctivitis. On the last occasion, my lord,
Three. The 3.
this one is 3 or 4.
Recovered?
4.
Oh, no, my lord, this was not recovered. This was the matter in connection that this missing lady got married to one of the person against whom a complaint was lodged, and subsequently she gave divorce to this particular person and got married with another person. Now she was leaving that person too because this was done due to family pressure. Now while she was returning back, it was a complaint that the first husband of her has kidnapped this particular lady. This was the allegation, my lord. Now, on the last occasion, we placed the report before your lordship, but the annexures were not there. That may I place it on record?
She is adult.
No. She is a minor.
Yes, minor Lordship. Let her
Now-
for the magistrate court. If that be so.
Wait, let us.
তিনটে দিয়ে ফেলেছে ইয়ে বাবু
এটা ফেরত
Subsequent
দিয়ে
আবার
দাও।
একটা হয়েছে।
After filing this writ application, the private respondent Lordship filed this. Same.
What is the
Lordship, the principal accused is Hon'ble Sardar.
Najbul Sardar was the first husband.
Yes, my
And now she has married whom?
Now, Mijanur Rahman,
He is not a party here.
he has not been made a part.
Now she is residing with Nijamur.
Lordship, we were trying to track her, but we couldn't got that she was residing with Mijanur because the complaint was that she got married to Mijanur under family pressure. She was,
In their complaint.
yes,
Now this is the petitioner is the child girl's father.
yes.
Father of the
Huh?
father of the victim.
Only one indulgence, my lord. We are committed that since she is a minor, we have to find her. We are aware of this fact, but the fact also remains that she was given married to Mijanur Rahman. That was done with the consent of the parents. It was even though she was a minor.
We are not
Yes,
concerned
yes,
with that. You only tell us where she is residing.
Lordship, I will.
Whether she is residing with Mijanur's residence, then you tell us. We will.
I humbly.
You know everything. Let her produce. You know everything.
No,
Let
my
us
lord,
file an habeas
my
corpus.
lord, after
You have suppressed
No, my
because
lord,
this marriage, second marriage which was given was with your consent.
no, my lord, after filing of my writ application, they lost this complaint, my lord. Kindly see.
Yes. What they will do? Your first complaint was your girl has been kidnapped.
Yes, my lord.
Now they upon investigation has ascertained that the girl has married another person.
How they know, my lord? If lordship she produced before the magistrate court,
Lordship,
if,
I am
recorded her
humbly
on
praying for 10 days
lordship,
time because we are confident that we can produce this girl before your
let her
lordship.
produce, my lord. The girl. All the truth will come.
Now this Najbul was never arrested.
Never were arrested. The allegation is that she has fled with Najbul.
She has fled with Najbul.
Yes, the first husband.
নাজবুলকে কিডন্যাপ করার ইয়েতে বাহাদুর সরকার নাজবুলের বাবা একটা কেস করেছে এদের বিরুদ্ধে। সেই কেসটা করেছিল, এই কেসটা 16 সালে। নাজবুলের বাবা এসে বলছে আমার ছেলেকে কিডন্যাপ।
ছেলেকে না।
না ছেলে আমার পুত্র নাজবুল
Is present.
আমার পুত্রকে জোরপূর্ব কোথায় গেল জায়গায়
এটা তো টোটালি উল্টো গল্প।
উল্টো করে দিল। আর এইটা হচ্ছে মাসার
এখানে বলছে দেখো রিপোর্টটাতে ডিউরিং ইনভেস্টিগেশন where is your complaint? Which page?
Case, my lord. 20, annexer 50.
এই কমপ্লেনটা তো হচ্ছে 4/8/2023।
8
ওইটা কত? 156
এইটা 156 ক্রস করেছে 16/7 কেস স্টার্ট হচ্ছে।
16/7 সেখানে কি হচ্ছে?
সেখানে বলছে নাজবুলকে উঠিয়ে নিয়ে গেছে।
So after this complaint, you filed another 156(3) before the court.
No.
No, my lord.
No, my lord. It was done by
It was done by them, my lord.
it was done by the person who was made the private respondent in this writ petition.
Made complaint.
That is
after
Bahadur Shaddar.
Bahadur, who is Bahadur?
Bahadur Shaddar is the father of Najibul. Private respondent.
11
So this, in course of investigation of this complaint, that
Fine.
is first complaint of the petitioner.
Lordship,
You have ascertained that they were Najbul, she was having a love relationship
and we have also got to know that she got married with
with
Najbul.
another person.
Firstly with Najbul, and second, after leaving Najbul due to family pressure, she got married to one person, namely Mizanur Rahman.
Mizanur Rahman. And thereafter Najbul again kidnapped.
Yes, because she doesn't want to stay with Mizanur, she was retired.
So any complaint was lodged by Mizanur?
No complaint was lodged by Mizanur.
So now your investigation reveals that the girl is now with Najbul.
Yes, Najbul. And Lordship, we sent those mobile numbers of this missing lady for the CDR extraction for the reports.
No, but at the same time, Najmul's father says
Yes,
that Najbul has
yes,
also
yes.
been.
They have lodged a complaint under 156
Earlier
clause 3,
lodged the complaint,
which was
huh?
registered as an FI.
So now what is your prayer?
My
You
prayer
say
is, my
that
lord-
you would be conducting raid.
Yes,
Now Najmul was never arrested.
never arrested.
From my lord 8th of March, Nazmul and the victim are in the same.
Lordship, may I
But
humbly,
the private respondents are not cooperate with the police.
Have you served the private respondent?
Yes, my lord.
খুব সময় ওই
Heard Mr. Islam. Heard Mr. Islam, learned advocate, appearing for the Mr. Islam, learned advocate, appearing for the petitioner, submits that the petitioner's daughter, who is a minor, has not yet been recovered. Has not yet been recovered, and the police authorities have not taken appropriate steps on the basis of the complaint lodged by the petitioner. Stop. Mr. Kobi, learned advocate, appearing for the state, however, submits that the petitioner's complaint was registered as Hon'ble PS case number 480 of 23 dated 16 July 2023. Huh?
no, my lord, this was the second one.
কোনটা দিয়েছে?
The
এইটা
first FIR is 154 of 2023, dated 8th March 2020. It's at page 21 of the report.
Hon'ble police station case number 154 of 2023 dated 8th of March 2023 under section 363, 365, 34 IPC. Stop. During investigation, it was found that Najbul Sardar and the victim lady and the victim girl belong to the same village, and they were having a love relationship. And subsequently they got married. Stop. Subsequently they got married. Stop. Thereafter, owing to family disturbance, the victim girl left her matrimonial house and gave talak to Najbul Sardar. She thereafter entered into a new relationship with one Mizanur Rahman and married him. And thereafter, the victim girl, she thereafter married one Mizanur Rahman. Stop. Later on 5th March 2023, Najbul Sardar allegedly kidnapped the victim girl. Stop. Several attempts have already been made to recover the victim girl, but in vain. However, raids are being conducted to secure the arrest of Mizanur Rahman and to secure the arrest of Nazbul
Najbul.
সেটা, are being conducted to recover the victim girl. ঠিক আছে? And Mr. Stop, next para. Let the report as file, as file be kept on record. Mr. Kobir learned advocate prays for some more time, so that in the meantime, appropriate steps can be taken by the investigating officer to recover the victim girl and to ascertain the whereabouts of the victim girl and to recover her. In view thereof, list the matter for further consideration in the daily supplementary list of this court on 13th September, on the returnable date, the investigating officer shall file a further report as regards the status of the investigation.
Grateful.
13 September.
13 September.
জয়ন্ত, ওটা মনে রেখো শুক্রবার কিন্তু next.
Shiba, I am appearing for state.
My lord, I am for the petitioner, my lord. My lord, in this case, my lord, petitioner's husband has been missing from long time, 37 years above. And petitioner has been left from his matrimonial house when her minor daughter is 1 year of age, and thereafter petitioner is staying at her paternal house at Bakura. My lord, petitioner several times gone to the office of the concerned authority like as district magistrate and police authority, but they are not helped the petitioner, and still now petitioner's husband is missing, and petitioner does not know that whether her husband is still alive or not.
So what were you doing for 37 years?
My lord, petitioner
Suddenly one fine morning you thought,
no,
after
my lord. At that time, my lord,
he is missing for 37 years.
years
So
ago,
what did you do during this period? Where you have stated
petitioner
that why,
approached to the police station, but
where have you stated?
that kind, my lord, that document has not case out because very old days time. Or, that time, and petitioner is driven out from her matrimonial house by her in-laws members, and thereafter petitioner decide to along with her minor daughter reside to her paternal house at Bakura. My lord, after that 37 years,
Yes,
petitioner
what
came
is
to
the-
know.
Lordship, not a single missing report has been filed. Lordship, 37 years ago, but no date has been specified in the petition also that when he was missing from when. And Lordship, as on date also, there is no specification of where, from where and when he was missing. She has only specified that the petitioner is missing. Lordship will find that the report is here,
My
Lordship.
lord, last petitioner came to know and last petitioner made representation before the district magistrate and police authorities. I have annexed my lord P3, my lord. The petitioner want to know that whether her husband still alive or not, or where.
So you say that your ASI, he
Yes.
went to the village of the petitioner's husband.
Petitioners,
Now, what did his family members say?
Lordship, then that is not reflecting here, Lordship. Then I have to get back with that information because
No, some information. they
because
might-
Lordship will find that the ASI tried to communicate with the petitioner, but her phone number was not there. He couldn't communicate. Then after getting the phone number, as he is saying that she is residing in the matrimonial house, but Lordship, it
no,
is
no,
written
your
there.
officer contacted her.
Yes, subsequently, Lordship,
No, no,
subsequently.
we are only wanting to know that whether the officer went to the place of the petitioner's paternal house. Sorry, the missing husband's
Husband's
paternal.
paternal
So
house.
who are there? What they have said? তাই না?
Lordship kindly gives direction to the petitioner to provide the details of the paternal house where it is situated because
Yeah, there is nothing in your petition.
My lord,
There is
only
nothing. If you
petitioner-
want
only my lord
remedy,
seeking that her husband is still alive or not, or
for that High Court is there after 37 years. High Court will.
my lord,
No explanation whatsoever you have given as to why did you not make any sort of attempt for these 37 years.
that time by the torture of the in-laws family members, petitioner has been driven out, and then petitioner take her
Why do you
minor
want to
daughter-
know? Why do you want to know whether your husband is a Borgadar or not?
My
Why?
lord, that is the record of the record, my lord. P2, my lord.
Property দেওয়ার জন্য।
P2, that record shows that petitioners and petitioners in-laws family members is still there, my lord.
এখনো ওই বর্গার ভাগটা চাইছে এই যে
হ্যাঁ।
বর্গার দখল আছে না actually।
If there are any assistance by petitioner to the police, petitioner also ready to
Now
help.
you want the property of your husband. This
Lordship.
is the story. That is why habeas corpus.
My lord, that is Borgadar petitioner husband Arun Rai is still the Borgadar of the land.
Hmm.
But petitioner came to know that her in-laws family members tried to sold out the property of her husband. That time petitioner approached to the district magistrate and also to the concerned police authorities. But and also
That
that
you have remedy under the law. You have remedy under the law. If your husband's property, you have not been divorced.
no.
So if your husband's property is being sought to be sold out by the husband's members, family members, you have other remedy.
Not only, because petitioners only seeking that sought for that petitioner husband, whether my lord, kindly any call for report to the comprehensive report that and assistance of
করবে after 37 years
Yes,
what they will
if any assistance from petitioner is ready to give any assistance to the police authorities or any other authorities.
Lordship,
For that, you have to lodge a formal complaint, if at all.
That
You have to
time-
file application under 150cc because they will not accept. You have to approach the magistrate. If the magistrate is satisfied, magistrate will direct them to lodge a complaint and continue. But this is not a habeas corpus.
My lord, very old time, that time petitioner.
Right.
almost after 37 years petitioner has knocked the door of this court. A prayer for issue of writ of habeas corpus for protection of the body of the husband of the deceased. Mr. Such and such submits that the husband of the petitioner, namely Arun Rai, went missing way back. He went missing 30 years ago. 30 years
No.
ago.
হ্যাঁ ওটা ফাইলটা দিয়ে দিয়েছি
with 37
Okay, Mr. Yes, such and such submits that the
married হয়েছিল
petitioner married one Urun Rai back in Sotoru 30 years ago,
37 years.
37 years, and they are blessed with a female child. And when the said female child attained the age of
মানে
one year,
হাজবেন্ড বেঁচে আছে
Yeah.
কিনা সেইটা জানার জন্য তো ওটা তো-
then her husband went missing.
7 বছরের
সে তো 7 বছর হয়ে গেলে সেটা তো এ হয়ে যাচ্ছে
ডিক্লেয়ার করছে
She was tortured by her in
7 years হয়ে গেল
She also
Being subjected to mental and physical cruelty, she was forced to leave her matrimonial house and take shelter in her paternal house. She approached the police authority to trace out her husband. She approached the concerned police authority, local PS. But the police authority did not take any effective steps, and hence he has been constrained to paper this petition. Mr. Miss Praja Maulik submits that no missing diary has been lodged. And no steps has been taken by the petitioner. Or no missing diary was lodged.
contemporaneously.
Obviously, it
No date, the date from the date যবে থেকে missing সেটাও তাহলে পিটিশনে বলতে
and no particulars have been given from which date and even from which date the husband of the petitioner are missing has not been disclosed. Now only to get the share of produce from the land in which the husband was burglar, the petitioner has approached this court. So, at the learned advocate, where is the
in the year 2000.
and after filing a petition in 2022, the petitioner has approached this court.
Petitioner complaint to approach the report thereafter. First complaint হয়েছে P3
এটা করেছিল
P3 তার কোনো ডেট নেই। এবার P4 এ যেটা আছে সেটাতে কোনো ডেট। What is the date of your representation? P3, P4?
My lord, date 1st July.
Where do we find it?
My lord, inadvertently that in that annexer, my lord, I have not annexed the copy of the date, my lord.
11 July.
But received copy of the postal track report. I have
11
annexed.
July of, it was received on 11 July. No, 11 July file করেছে, কোনো ডেট নেই। আচ্ছা, report
Both the representations are undated.
report as produced by Mr. After filing a
After filing a representation in the year 2023, the petition has
আবার কি বলবো একই
My lord, as my instruction
report as
taken, my
produced,
lord,
report as produced,
at that time petitioner lost missing diary in the year 1995, and that time NTPS police station was not existing.
আচ্ছা হারদা লালনেট অ্যাডভোকেট
The missing report has not been annexed, Lordship,
No,
and we
in
have
previous
searched
police
for it.
station,
There
they
has
have
not been,
received.
yes, but they have searched for the missing report. There has been no existence of the report.
This jurisdiction is a discretion.
আরে অন্য police station এও খোঁজ
And
নিয়েছে, সেটা আমার রিপোর্টে
The court may
স্পেসিফিকেশন আছে,
refuse
নেই
to
রেকর্ডে
exercise
কোনো
such
মিসিং রিপোর্ট।
discretion in case of inordinate delay. ঠিক আছে। From the record, it transfers that although the husband went missing almost 36 years ago, but no effective steps has been taken by and on behalf of the petition. So, from the materials as produced before us, it does not suggest that there is any substance to lead us to infer that the petitioner husband was wrongfully restrained by any person or authority. Wrongfully detained by any person or authority. So,
Where have you said about the missing?
circumstances,
My lord,
we are not
in the year,
inclined to interfere
as-
with the
Where have you
petition.
stated?
my lord, that is not stated, my
Where
lord.
have you stated in the petition?
We
Not
are not
stated.
inclined to
Stated.
interfere in the petition.
After filing
Accordingly,
that
the petition stand.
taken instruction that in the year 95,
However, it is clarified
missing
that
diary has been lodged.
this order shall not preclude the petitioner to take appropriate steps in
In accordance with law.
accordance with law in the appropriate forum.
Disposed of Lordship.
Grateful, Lordship.
This means liberty is given to you to take appropriate steps in accordance with law in appropriate forum.
Grateful.
Item 6, my lord, I appear for
And
the
by the
petitioner.
state
My lord,
law.
I have received report on the earlier occasion from my learned friend. My lord, it appears from the report, my lord, the death certificate which they have annexed in their report is also annexed with the read application of mine. Now, my lord,
Also,
it is also annexed in my read applications. My lord, initially what has happened is, my lord, they went to give the dead body of my father. The hospital authority went to deliver the dead body of my father. Previously, they have given the copy of the death certificate. Subsequently, I found that this is this is not the dead body of my father. It is the dead body of someone else, and it's a female dead body. Thereafter, my lord, I have returned back this document to them, the death certificate which is annexed in their report.
when did your father expire?
My lord, in 2021, 17th
You
of
are the
April,
son.
2021. Yes, I am the son.
Your father expired in
COVID.
during the COVID period.
COVID. I went to take the dead body from the hospital.
Uh.
They went to hand over a dead body.
Hmm.
I want to see the face of the dead body.
Hmm.
This was a female dead body. I refused to accept. The dead
That
body
was
which
in
is annexed
2021.
2021.
Then you lodged a complaint.
It has been that complaint has been culminated into a FIR. Subsequently, it appears from their report that FRT has been submitted. Now, my lord, my respectful submission before your lordship is that the death certificate which is annexed in my petition is similar to the death certificate which is annexed
No,
in the.
but the fact that your father has died is.
My lord, I don't
admitted.
know. I don't know. This is my case. My lord, in the writ of habeas corpus, either they have to give the dead body or the person alive. Kindly have a look at the death certificate once from their report.
Hmm.
Date and time of death, 17th of April 2021, 10:40 AM. Thereafter, very last line. Death certificate issuance time, 10:40 AM. Where is the 4 hours limitation? Before 4 hours, how they can issue the death certificate? They have to wait for at least 4 hours to ensure the death to their satisfaction.
Yes, what is your case?
Lordship, then I have to come back with the report from the hospital. This is not, the police has not issued the death certificate. It is given by the hospital.
No, no, you have registered that case as a FIR?
Yes, Lordship.
So, what investigation you have done?
My lord, they have submitted
Wait,
FRT.
wait.
Lordship, subsequently investigation was completed and FRT was, what I find.
Oh, FRT
Yes.
was filed.
Yes, mistake report filed. Yes, Lordship. Final form of report, Lordship, second page, Lordship, the report which I've handed over in the last occasion. Second page, first paragraph.
Where is your complaint?
My lord, my complaint
Page number, Lordship,
is that, my lord,
28. Page 28.
27 is the formal FIR and 28 written complaint. It starts.
বিধিনিষেধ
It has been-
অপরাস্ত করলে এলাকাবাসী পঞ্চায়েতের কোনো আপত্তি নেই।
So, fact of this is admitted.
Actum of date almost
FRT টা আনো।
উত্তরার্থী মারা গেছে, সেই কারণে উত্তরার্থী মৃতদেহ যাতে তার পুত্র করতে যাওয়ার দেওয়া হয় তাকে সুপারিশ করতেছে।
Where is the FRT? Do you have that?
Lordship, it is not annexed herewith. As I find, it is not annexed herewith. If Lordship directs, I can ask for the details of that report.
কাউকে দেওয়া হবে না।
You bring the effort. Let us see.
Yes, Lordship.
Yes, keep.
Only one indulgence, Lordship. This FRT was also given last year in September. Till now, the petitioner was silent and he had no
My lord,
complaint against
we have not
Wait,
sought.
why you make submission when he submit? You'll get your turn. Yes.
till now there was no
No, you
petition
bring
filed.
us. We want to
Yes.
read that.
Yes, Lordship. I'll just ask for.
Because during the COVID period at one juncture, dead body was not being handed over.
Yes, Lordship. That was the incident. The
No,
dead
no,
bodies were.
but the factum of death, he is disputing. He says that is not the body of my
Yes,
father.
but his own signature is there when he, where he has
Obtained in
written
the
that.
blank paper.
that-
That has been obtained
No,
in
not
the
in a
blank paper.
blank paper. It is
Of
written. Of course, it is not on a blank paper. Lordship will find at page number 5. It is written there. His signature is there.
Come to page 25.
দাঁড়াও, কি বলছে আগে?
Where the Pradhan of Islampur Gram Panchayat, he stated that from hospital it was informed that your father had expired. Thereafter, he made a recommendation to the block development officer so that the dead body is handed over to you. However, he stated that if the dead body is cremated, giving honor to the Islamic rules and the COVID
Blood, may I submit?
protocol,
May I submit?
he shall have no, the people of the locality shall have no objection.
Blood, initially we received a telephonic call from
And
one
he-
of the staffs.
Very difficult to control you. You do not listen what we are saying. You will get your turn. Take your seat.
And you put your signature on that letter.
FRT টা নিয়ে আসুন। Bring the FRT
Bring the-
next Wednesday.
Great.
Not this week করে রাখবো। And you show us whether you ascertain whether because at that time a permission was required from the block development officer, if I am not wrong. if any such attempt was made by your officers.
Yes.
Yes, come back next Wednesday.
Date for it.
Next Wednesday you can.
Yes, Lordship, I'll do.
Yes, next.
My lord, I am for the My lord, here the petitioner resides at USA along with his 2 children and wife. Last year,
Yes, what happened?
but my lord, I wrote a letter to the learned advocate so that we can sit and settle the issue. This is the letter, but my lord, no initiative or any reply was given from their side, my lord. This is the letter which I said that we want to sit.
They are not sitting with you.
Oh my.
Now tell us what is the story.
My lord, the petitioner and the respondent got married in the year 2010. Thereafter,
Who is the respondent? Devjani Sarkar.
yes, my lord.
She was your wife.
After marriage, the petitioner got a job at USA. There, took
After marriage.
after marriage, he got
So they were married in
India.
India. Or
Thereafter, he got a job and went there along with his wife.
Hmm.
Thereafter, 2 children was born. One was daughter born in the year 2013, and one is the son who is born in the year 2017. Thereafter, my lord, there's some dispute cropped up. The private respondent made several allegations to the employer and the Indian embassy there to terminate his job. And in spite of those allegations, she used to reside along with the petitioner in the same house. Thereafter, my lord, in the year 2022, they returned to India for annual visit to the matrimonial to the parents' house. There, my lord, some dispute cropped up, and she filed a complaint under section 498. And when she filed the complaint, thereafter the petitioner has to return to America because the schools are going to be open. Thereafter, she again returned to America, and in the complaint, she said that she is the permanent resident of the place where the petitioner was residing at USA. In the 498 complaint, I have annexed the complaint, my lord. Thereafter, in the month of September, she returned to America. There, they decided together. Thereafter, in this year, in the month of July, they all returned to India to pay the annual visit, as the schools were closed. And therefrom, both of them went to the
where they were residing in when they returned.
Nakashipara in the house of the petitioner. On 6th
The
of July,
petitioner is a resident of Nakashipara. And where is his in-laws' house?
Noihati.
It's Noihati.
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 So son was born on 7th of August 2017.
My lord, yes, 7th of August 2013.
And the other child
2013. Girl is the elder. The daughter is the
2013. So 10 years and 6 years.
elder.
5 years.
So when did you last return to India?
My lord, in this year, 6th of July 2023, 4 of them returned to India.
July 2020.
Right.
But before that, there was a judicial separation application.
My lord, the petitioner himself only singly came to India and filed a complaint, filed a petition for judicial.
Leaving the wife and the daughters in USA.
Yes, they were there.
So he came back to India and lodged an application for judicial separation.
Thereafter, he returned and both of them are residing together. Though
Very
there was some dispute.
Now thereafter he has again returned with his wife and children in July.
In July, they were residing at the parents' house of the present petitioner. And on 18th of July, suddenly some police persons came and took away the children with them. And till that day, the wife was with the petitioner. After that, the wife left. And on last occasion, we came to learn that the children are with the wife. And both the children are US American citizen. And my lord, one new thing that I came to know, just that the boy is suffering from autism and some speech problem. And my lord, this is the report. My lord, I have only one copy. and the treatment is going on there. And the girl also had some speech problem that has been cured after 4 years of treatment. This is the Mala report. And their school is going to be open on 28th of August.
So after returning in July 2023, the children were admitted in a school.
No. They were
They
their
were
school-
admitted in states.
Yes, madam. They were reading there, and the girl is a student of class 3 and the boy is a student of grade K. Their school at USA is going to be open on 28th of August.
28th of
August. And their treatment. the
yes, what do
court is-
you say?
My lord, the mother, that is the wife, is present today outside the courtroom. There is a 498 case pending. There was an
When
incident.
did you lodge the 498?
It was my lord, there was a domestic violence act case, DV Act case, and there was a 498. The FR was lost on 30 FIR dated 2/7/2022.
My lord, it is annexure P2. Page number 22.
2nd July 2022.
22. My lord, there was a fresh complaint dated 18 July.
April 22.
Well,
498. তারপরেও judicial separation.
Look at there, the address of the petitioner, kindly have a look in the 498 case, first paragraph. Address of the wife.
My lord, there was a fresh complaint on 18 July for which a police report has been filed by the respondent police officials. Your Honor, may kindly peruse those things that will enlighten the honorable court.
Okay, on which date you filed application for judicial separation?
My lord, we did not file. We are the respondent therein.
No.
No. Vishwajit Sarkar filed.
তুমি করো পরেরটা দেখি পুলিশ এসছে
এটা
পরেরটা পার্সোনাল
My lord, in the month of April, the judicial separation case was filed.
So now you do not want to return to USA.
My lord, the wife is afraid along with the children. There is a police report filed that might reveal certain facts.
No, we are asking you, what does your client want?
As far as I have inquired, my lord, they are afraid to return.
They,
Along with the children, are afraid to meet even the father of the children.
পাশে করেছে এটা Thereafter, another complaint has been lodged.
My lord, that knowledge is not with me, my lord, kindly see the date, 18th of, they are saying that 18th of July, the complaint was lodged. 18th of July is the date when the police came and they took the children with me. And I would say, my lord, only to save the back, this complaint has been lodged by the police after subsequent.
My lord, there is a police report regarding this.
American citizen, এখানে কি করে return? কিন্তু অটিজমে সাফার করছে বাচ্চা দুটো। Yes, what do you say?
Lordship, preliminary investigation shows that, Lordship, there are several one domestic violence case and one judicial separation has been filed. It is a complete dispute between the father and mother. And Lordship,
They are alleging that you forcibly took away the children.
no, Lordship, on 18th of July 2023, we received a complaint on the basis of which we took action. It was a complaint made by the father of the wife. Lordship, on the basis of that complaint, we
Take
took
it up.
action, Lordship. Second page, third paragraph, Lordship. Second page, third paragraph.
That's the thing. Yes, that's,
Who are there? Your wife's parents are there.
Yes,
You are not a working lady.
at present I'm not working.
How will you maintain your children?
I have to find work, my lord. The little boy, age 6 years, he's actually having some speech problem, suffering from autism. And another one is a female lady of 9 years. I have to find for work and maintain them. And if the law permits, I have to beg for maintenance. But I've tried my best, my lord, but they are afraid.
Why you are not negotiating and settling the problem?
Tried, my lord, I've tried, but there is some fear amongst the client.
No, they can sit in presence of the concerned advocate, my lord. There is no such.
Even they are waiting outside the court, my lord, both the parents.
The husband and wife, both
Yes,
of them
my-
are present.
Yes,
Yes,
both
my
of them
lord,
are
my lord,
present.
What does the husband do in United States?
My lord, he does a job there.
He's not a citizen of USA.
My lord, he's a software engineer.
My lord, the mother is present in the court.
বউকে নিয়ে যাওয়া হচ্ছে। ওকে spend.
My lordship, the mother is present in the courtroom.
Father, where is father?
My lord, he is a father.
What is your client's qualification?
Bachelor of Arts graduate.
And the husband?
Software engineer.
Software.
Software engineer.
So, madam, if we say that the wife along with her children will accompany you, you are not ready to take them because you wanted judicial separation.
My lord, the situation was such that.
No,
my lord,
let us understand. Today, if we tell the lady that you go along with your children, accompany the husband, go to America. Once she goes to America, the state's law will prevail because they are American citizens now. So what is the guarantee that you will properly treat your wife? Because you yourself do not want to reside with her.
my-
This is a fact. You filed a judicial separation application. So what is the alternative remedy? How can we tell the wife that you take your both the child and accompany your husband who does not want to reside with you, having filed the judicial separation application? You tell us, what will you do?
My lord, even after filing the case, both the parties, she also filed 498, I filed.
We can take the horse to the water, but we cannot compel it to drink the
Yes,
water.
yes, my lord. My lord, after that, both of them resided together in America and even in India.
Whatever is your argument, try to ascertain this. Have you withdrawn your judicial separation?
And
You
now
have
no
not.
cases has been withdrawn, neither by the lady, neither
So
by
very
my-
good. So there is an acrimony between you two.
Yes,
You have filed a judicial separation application. Now today, for the interest and welfare of the child, because you have the monetary basis to maintain your child. So she is a lady, she's not a working lady. So now you say that I do not want to reside with my wife, but I want the children. This is your.
My lord, at present, that is why we
So
want.
for that, madam, you have to approach the appropriate court
My-
for custody.
For custody, you file custody application before the court.
That will take time, my lord. Both the children are, the treatments are going on, my lord.
Will
and
give you-
their School is going to
Eh,
be open.
Kindly tell us whether in that circumstances, can we hold that the custody of the child is illegal?
My lord, that I cannot say that the custody of the child is illegal, but my lord, I can say that even they are in custody of the wife, I can file this case for the recovery of the child. My lord, there is
Then file.
this petition, my lord, habeas corpus.
Habeas corpus is a summary proceeding. Guardianship application has to be decided.
My lord,
Point.
that will take time, my lord. My lord, I
That
have
will
got-
take time. You will get visitation, right? You will visit your children.
My lord, I have
You
got
you
several
ex-
challenges, my lord,
You
where-
extend your
my lord,
assistance.
that is why we wanted to sit with them and have a talk with them so that the.
So, madam,
issues may
we
be
also
settled.
said that you sit,
my
but
lord,
we
they-
cannot compel.
Yes, my lord, they can
Neither
be
you can
but
compel
I
your.
will see whether they were, what was the wish, my lord. We wanted to sit with them and settle the issue, but they have not approached anything. They have not.
You
done anything.
approach them before filing the petition.
My lord, he
198
was not aware where the children were.
So those are disputed questions. How can we
He
go
was
in?
not aware because the children were taken by the police. We are searching for the children. My lord, we made what we gave. What?
Now you have come to know the child is with the mother,
Yes, my lord.
and the mother is now residing in her paternal house. So you file custody application.
Well, that will, my lord, it will be very difficult for him to reside at America and come here and
We cannot transfer this application or treat this application as a custody application.
my lord, I am not saying that, my lord, but my
Then what are you saying?
several observations were given by the Honorable Apex Court that the paramount consideration would be the benefits of the child.
Exactly. You have the monetary power. You are a working person.
My lord, not only the
So tell that to the custody court. Tell that to the custody court that she would not be able to look for the treatment and education of the child. You will get the custody.
question, my lord, whether these two children, one who is suffering from autism and speech problem, they will be treated by the wife here well, and they will get proper education here. But what will be their benefit when they are citizen of America?
Actually, you want to snatch away the child from the mother,
Not
from the
at
lap
all,
of
my
the
lord.
mother, and go to
That is-
America.
Not at all,
That
my
is-
You
lord.
will not take your wife.
Four of them.
You will not take your wife to America because you want judicial separation.
That is the case, my lord.
So what analogy can be drawn from your conduct?
To
Tell
get
me.
that, my lord, the issue may be settled, my lord. If
Settle
we
the
are
issue.
allowed
We
to settle
granted you time.
We granted you time.
But my lord, we approached, but they were not at all willing to.
All right. You
settle
do
the
one
issue.
thing. You pay 5 lakhs to your wife. You pay 5 lakhs to your wife for the upbringing of the child. And you sit for a negotiation.
My lord, for the upbringing of the child, my lord, without meeting them, I am not.
Yeah,
allowed
we
to
will
meet
allow you to meet with them. We will allow you to meet with
them. How they will.
them. Then how they will survive?
they are-
How they will survive?
They are coming from Noihati, my lord.
My lord, he is willing to take her back if she behaves properly.
What is
No,
the
no,
guarantee?
that-
Tomorrow he will go to states, he will file a custody application there.
They are also they
Huh?
can.
There is a judicial separation. Huh? You
My
will
lord,
throw away
there
your
is
wife.
also law that if she is treated ill
What
behaved,
will the hard option tell us? Tomorrow, if you go to United States, children are citizens of United States. There, the husband will go, and if the wife goes away from the husband, he will immediately approach the court there. Court will say that, yes, hand over the custody. Where will the lady go?
my lord, they were.
Will be ousted from her house.
How does the benefits of the child will be taken into consideration?
Sorry, madam.
My lord, several judgments are there where both the children were sent back to America considering the benefit, my lord, as or both the children.
Yes, argue. We will
Argue,
deal with
yes.
the judgments.
My lord, can you see this?
Yes.
My lord, in both the judgments, paragraph, page number,
এটা কপি দেওয়া যাবে?
Yashita Shau, yes.
paragraph number 11, my lord. There an observation was made, my lord, whether the factum of the base interest of the minor child is to return to the native country or otherwise. The fact that the minor child, my lord, lordship got, my lord, page number, paragraph number 11.
Yes,
It is in the third line, whether the factum of the base interest of the minor child is to return to the native country or otherwise. The fact that the minor child will have better prospects upon return to his or her native country may be a relevant aspect in a substantive proceedings for grant of custody of the minor child, but not decisive to examine threshold issues in a habeas corpus petition matter. For the purpose of habeas corpus petition, the court ought to focus on the obtaining circumstance of the minor child having been removed from the native country and taken to a place to encounter alien environment, language, custom, etc., interfering with his or her overall growth, grooming, whether continuance, there will be a harmful, my lord. My lord, they were born and brought up at America. They are reading there, my lord. If they are taken here, my lord, if they are start residing here, that would be some alien environment for them. My lord.
this will help you in the custody application, not
But-
in habeas corpus.
But my lord, these observations were made in habeas corpus, and in this judgment,
Any other
two of-
judgment you want to refer?
my lord, these two. My lord, in this judgment, the child.
Come to my chamber at 2 o'clock, along with your client, both of you. Yes, রাখুন file. Not to be. File টা চেম্বারে পাঠিয়ে দিন।
আমাদের
নৈহাটি?
No, my lord.
One
My
from
client is
Noihati.
Nakashipara, Nodia.
হ্যাঁ তো। I won't, at 2 PM it may not be possible. Can you, both of you wait till 4:30? Ask your clients.
Yes, my lord, my client
There
can.
is a small boy actually for the mother.
She has
In-
brought the child.
My lord,
No, the girl is with the boy is in the house.
Oh, আচ্ছা আচ্ছা। Right, come at 1.
My lord, may I say one thing, my lord, client, my client wants to meet with the daughter, my lord. May this court be allowed to meet with, have a talk with the daughter alone, my lord? Because for last 1 month, there is no communication between the daughter and the
We
father.
will pass necessary order.
My lord, the daughter is here, my lord.
Where she is in court.
Yes, my lord.
You have
Let the
brought
mother
your
be
child.
present. Yes,
My lord, in
we are not
absence,
obstructing.
Not in front of.
We
the
are not
mother.
obstructing.
My lord,
That-
in presence of mother, she is
that-
absent to talk with the father.
That baby girl is afraid, my lord.
My lord, they can sit and talk in this court.
শুনে নাও, শুনে শুনতে হবে। কি বল? আমার বাচ্চাটাকে নিয়ে 1:30 অব্দি দাঁড়িয়ে থাকো। 10 মিনিট meeting টা করো। হ্যাঁ, সেটাও To sit and negotiate the matter with your husband.
My lord, the wife is afraid. The last occasion which my learned friend is mentioning that she
Talk
went.
with the husband why you are afraid. You are in Calcutta now. What is your problem in talking with the husband?
She is afraid, my lord. On last occasion, what my learned friend was mentioning that they were going to USA, that was not in any normal circumstances, my lord. The father took away the children. Thereafter, the embassy arranged the mother to reach USA.
Embassy arranged.
Yes, my lord.
The payment, the tickets were bought from the credit card of my client.
Yes, that was bought. But the Indian embassy arranged the wife to reach USA.
Embassy?
Visa has to be given by the embassy.
What has happened?
On last occasion, what my learned friend was mentioning, that they went to USA along with the children and father. That is not the fact, my lord. The father took the children away from the mother and went to USA. And thereafter, her passport was seized. It was missing. Thereafter, a new passport was obtained, and Indian embassy helped this lady to reach the USA. And thereafter, she met their children and came back to India.
Where she stayed?
In the same house as arranged by the local police of the United States of America. They arranged this lady to stay in that house. An Indian embassy actually, in this case, intervened and helped this lady to reach the United States of America because the father took away the children. And thereafter, they came to India.
Tickets were bought from my credit
In
card.
the
Yes, the ticket was
circumstance, you
bought.
do one thing, you make an alternative arrangement for your wife in USA.
For accommodation.
Yes, the mother shall has the visitation right, and the child has right to enjoy the company of his mother. You cannot snatch away that right.
Well, I'm not
So
saying.
you are so financially affluent, and you are so arrogant that you will somehow snatch away the child from
At that point of
the
time,
mother and take them to USA.
that not-
Then
that
you
is
make
not the
alternative
fact.
arrangement.
At that point of
All
time,
right, you do one thing. This fact you bring by an affidavit before us. This factum as regards embassy interference and that she was not taken, you bring this fact before us by an affidavit.
Then allow us 2 days time, my
Yes,
lord.
when can you file that? Tell us.
By 2 days.
By day after tomorrow, you
Yes,
can
my
file?
lord, we can file.
All right.
well, if I
Day
have
after
some,
tomorrow, you can give a copy to your friend.
Will you be available? 3 days, my lord.
Ashok, hardly learned advocates appearing for the parties. Respect. Appearing for the respective parties. The respondent number KOE, Bhadramahila. The respondent number 6 is directed to file an affidavit in opposition by 21st August. By 21st, you can file.
Yes, my lord.
Reply there too, if any be filed on 23rd, 2 days, stop. List the matter as for others on 24th. You exchange your affidavits, we pass our orders.
My lord.
And on that day, none has to be present. Your wife is not required to be present with the child.
My
Child should not be brought to the court without our consent. All
My
right?
lord.
Take back the child immediately.
My lord.
Yes, call the next.
I am for the state.
I am for the petition.
In item number 8, my lord, I seek to intervene, my lord. I am the person, my lord, who is sought to be found by the way of habeas corpus. My lord, I am the father of the petitioner.
Peculiar case, my lord.
May I permitted to intervene in this matter?
I object to this.
My lord, on last occasion,
He is under the custody of the
Lordship.
local TMC leaders and they are doing it.
we are pleased to direct
Yes,
The-
one by one.
Inspector in charge to present before your lordship, my lord. He is here.
Inspector in charge must produce the body. Habeas corpus proceeding does not allow anybody else to enter.
Advocate is here.
The father of the petitioner. That was declared. Postage were taken. Declaration. PTO issued notice. That is the You are the father.
I am the father.
Amman.
Yes. My lord, I've spoken to my.
Wait. Yes.
Oh, that matter.
Yes, Mr. Chatterjee, what
The
has,
inspector in charge of the police is before your lordship. Apni asun sir.
yes. No, what happened?
Sir, kindly
What you
see
have,
the report. He himself came to the police station and stated that no one detained him forcefully, my lord. This is purely, if your lordship kindly permit me, my lord, this is a purely political matter.
Let the CCTV footage be produced.
My lord, I have also the pen drive of his statement, my lord.
Let the CCTV footage may be produced.
Acha, don't make stray comments. We will hear you. Please take your seat. We get distracted now when we are hearing you.
And the advocate of the
Wait. The father and the petitioner are residing at the same place.
No, my lord, I tell your lordship, my lord, the
Yes, my
father
lord.
has returned
Yes,
back to the
that-
house.
House means you are
Yes,
staying with
yes,
your
my
son.
lord. Yes.
Same house.
My lord, kindly see last annexure. The letter written in Bengali, my lord.
সুন্দর ইয়ে করা হয়েছে সুন্দর ডিলেটা মেনটেন করে ইয়েতে পাঠিয়েছিল বলে আমরা সিগনেচার ভেরিফিকেশন করেছি সিগনেচার ভেরিফিকেশন
কোথায়
by the signature of the petitioner. On the very next day morning, I sent that দিয়ে এইটা ও ডিলেটাকে ইয়ে করেছে 25 তারিখে কেসটা করে ডিলেট করে হ্যাঁ করে করবো
Which is the last annexure?
My lord.
That is the letter of
Yes, my lord.
2nd of August, when he met with the police.
Yes, my lord. The fact is, my lord, on 24th, the complaint was sent through registered post from GPO, my lord. They never went to the police station, my lord, but he stated in his petition that he went to the police station. Kindly see the annexures. And she is missing since 13th. And police was intimated on 24th.
What was the date of the complaint?
24th.
My lord, the date of the complaint is 24th, but it was sent from the GPO through register port.
On 24th.
Yes,
Yes.
and it was received on 25th. Thereafter, after preliminary inquiry, my lord, police had started the FIR.
In every case, you conduct a preliminary inquiry
No, my lord.
and thereafter you register FIR.
No, my lord. Your lordship, my lord, my lord is aware that in Ernest Kumar case, my lord, police shall register FIR. But in this type of case where there is a chance of wrong my lord, information before the police can
You should have
inquire
issued
preliminary.
41A notice then. You
My
should
lord?
have issued 41A notice then.
My lord, police went in his house
Where is
twice.
the notice? You have sent 41A notice.
No, my lord. Annexure is not.
363 prescribed punishment,
How Ernest Kumar is applicable?
10
No,
years.
my lord, 10 years.
Ernest Kumar most stated that below 7 years.
Below 7 years, my lord, but principle of the judgment, my lord. I am submitting it before your lordship subject to your
Principle of judgment has said that in spite of receipt of FIR, you will kept him. Thereafter, it will go on preliminary inquiry.
No, my lord, kindly see the annex.
And as and when it will seems fit to you, then it will register the
My lord,
case.
police have taken every steps, my lord. He himself went to another place and
And you are Amman Naiya.
Yes, my lord, I have taken specific instruction being an officer after reading the complaint and everything. My lord, I asked him to be personally present in court. And my lord, he says in front of me and is ready to say in front of my lords and magistrate
The
also
client is present.
is present. My lord, I have specifically inquired whether there was any compulsion to do whatever is happening. He said, no, I'm at my free will and
Son is
consent.
also present.
I don't know, my
Son
lord,
is
son
not
is-
present. Certainly from the morning we are calling. My advocate.
But the allegation is otherwise, I do not bring
Allegation
into that before
is
the court.
something, Lordship, I raise an objection for interference of.
My lord, he
any person
apprehends the
other than
allegation.
applicant in the habeas corpus proceeding. It's a proceeding between the applicant and the police. Now, my learned friend has stated, he has taken the instructions from the officers. I'm stating, Lordship, this may be investigated, that the officers only are pressurizing this person. This person.
This
should be
is
given
something a wild
for the
allegation.
polygraph test.
Here, person is here.
CID
Mr. Chatterjee.
should investigate this. This is happening.
That is your argument, Mr. Chatterjee. The person is here. It is not a case that he is missing. Your allegation is that this is being done politically so that he can be pressurized to vote for somebody else. That was your contention. That is why we asked the police
Yes.
that where is the record that he appeared before.
Present today. What is
Now he is present today. He says that I am residing with my son. So now how
son has
heaviest
not given the instruction.
we will record his statement. If it is a wrong statement, you have avenues open for that. If that is a wrong
But the
statement,
petitioner, the person missing is at his own house. He has come back.
No, Lordship,
My lord, he is residing with the wife. The son is free to come in. My lord, it's up to the son. My lord, now
where
there is
you are deciding now?
in the
your
house.
client- Ask your client, what is the address of his house?
My lord,
What is the address of his house?
অ্যাড্রেস বল বাড়ি পাঁচালি গ্রাম শঙ্করপুর অঞ্চল habeas corpus of the military vessel.
Lordship, may I-
Machani.
Panchali
Lordship,
Gram.
one question may be
Yes,
asked.
Golaha.
Did he participate in the voting? Did he participate in the date of voting? On
He
that day?
participated. He participated.
Lordship,
He gave the word.
পুলিশ করতে বলেছে তো
That is the report before us.
may I get a copy of the report and come?
Yes,
back?
yes, I-
One
We
day.
will record, Mr.
Lordship, the
Chatterjee.
only thing is that
my lord, may I be
He
permitted?
exercises, board
Voting power.
meeting, he exercised his franchise.
Would you conclude this proceeding
He
today?
says yes. He's
Do
saying
not-
yes.
Do not conclude the proceeding today.
My lord, may I be permitted, my lord? I have a short submission, my lord. Kindly see for a moment.
The
Prayer
present
B.
petition has been preferred.
Prayer B of.
Yes.
Lordship, may I
Prayer
get
B
a
of the
copy of the
petition, page
petition.
13.
May I get the copy of the report?
Did you have-
Copy
Yes,
of
yes,
the
I will-
report,
I-
and May I go through the report? Since yes, Lordship, kindly keep one.
Mr. Chatterjee, we are passing the order referring to the report.
Prayer B is
We are
complied
record-
with.
May I get the report?
Yes.
Otherwise, Lordship, raising a serious issue.
Ashok, Mr. Chatterjee learned that
Copy of the report. may
the
be-
present writ petition has been preferred, primarily praying for the following relief. বলে বিটা
My lord, May I
How
go?
to lead. We are not giving you to intervene, but we will record your appearance. Ask your junior to be here along with your client.
Yes.
Ashok.
আপনি আম্মান তো?
Mr. Chatterjee, learned advocate appearing for the petitioner submits that the petitioner's father, namely Amman Naiya, bracketing in short Amman, contested the Panchayat election held on 8 July 2023 and was elected as a candidate belonging to CPIM. Stop. Surprisingly, thereafter, Amman suddenly went missing from his residence on and from 13th of July 2023. Stop. Such fact was reported by the petitioner to the respondent number 8 on 24 July 2020. However, no steps were taken by the police authorities to recover Amman, and aggrieved thereby the petitioner approached this court. Stop. When the matter was last taken up for hearing on 9th of August 2023, we directed Mr. Chatterjee, learned advocate appearing for the state. No, in course of hearing, stop. Stop. Upon hearing the matter was last heard on 9th of August 2023, when we directed the investigating officer, being the respondent number 8, to be personally present before this court today, along with a detailed report as regards the steps taken on the basis of the petitioner's complaint, along with a copy of the alleged written declaration stated to have been executed by Amman. Stop. Pursuant to such direction, the respondent number 8 is personally present before us, Mr. Chatterjee, learned advocate appearing for the state, has also placed before us a report prepared by the said respondent number 8 on 16th of August 2023. Stop. Let the same as produced be kept on record. Stop. Mr. Stop. It is the allegation of Mr. Chatterjee. It is the allegation of Mr. Chatterjee that Amman had been illegally detained by the members of the ruling political party. On 9th of August 2020, when the matter was last heard on 9th of August 2023, Mr. Chatterjee alleged that Amman had been illegally detained by the members of the ruling political party, and that he would not be, and that he may be forced to cast his vote in favor of the ruling political party members on 9th August 20.
He has casted his vote for the ruling political party.
That is his
9th
fundamental, that is his right.
2023
হ্যাঁ
এই প্যারাটাকে মিস্টার চ্যাটার্জি ফার্স্ট প্যারাটার পরে এই প্যারাটা দেবে, তারপরে ওই যে আমরা ডিরেকশনটা দিলাম টু অ্যাপিয়ার পার্সোনালি। We have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. A perusal of the report filed by the investigating officer. In the report filed by the investigating officer, it has inter alia been stated that after the complaint was lodged, Amman himself appeared before himself attended the Dholaghat PS and met the investigating officer and submitted a written declaration stating inter alia that He has not been kidnapped, he has not been kidnapped. He had neither been kidnapped nor confined, and that none has allured or threatened him. Stop. The said representation dated 2nd of August 2023 has been annexed to the report. Stop. Mr. Chatterjee, Mr. Chatterjee,
Kushal Chatterjee.
Mr. Chatterjee learned advocate appeared and wait for leave to intervene in the matter. Stop. We have, however, heard Mr. Chatterjee. Stop. We have allowed Mr. Chatterjee to advance his arguments, and he submits that Amman, that he is appearing for Amman, and Amman is personally present before this court. He further submits that Amman is presently residing at his residence, and denies the allegations as leveled by the petitioner in the habeas corpus petition. Stop. 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 The records reveal that Amman appeared before the investigating officer and submitted a written declaration that he has not been kidnapped. Stop. Amman is also personally present before this court, and Mr. Chatterjee, upon instruction, submits that he is presently residing at his residence at Prayer B, village Pachani, police station Dholaghat, district South 24 Parganas. Stop. In the said conspectus, we do not find any material on record to infer that Amman had been illegally detained, and in view thereof, no further interference is called for in the present writ petition. Stop. The said writ petition being such and such is accordingly disposed of.
And Lordship, the officer in charge appearance.
Lordship, I have two submissions to make, Lordship.
No, officer in charge appearance should be disposed.
Lordship, I have two submissions to make.
My
Lord, I have two submissions to make.
personal appearance may be dispensed with, my lord.
Personal appearance.
Are they-
Matter stop.
My Lord, I have two submissions to make, Lordship. I could not able to
Had
submit
the
anything.
person, 1 minute, had the person brought any voter identity card or any other card, anything?
Lordship, affidavit may be called for.
Yes, Mr. Chatterjee, what do you want?
Lordship, affidavit may be called for from the person who is claiming that he is Amman. Because the petitioner is not present today, I am seeking time for that. Because otherwise, Lordship, he has wasted the time of the court. This petitioner should be imposed with the heavy cost.
Yes.
This court should examine that.
Any.
Because
identity
otherwise,
card
Lordship,
already-
this will set a bad trend. Somebody will come and interfere and come up with an affidavit, say that I am present in the court. So therefore, I was not kidnapped. Lordship, this particular thing possibly is not permissible in habeas corpus proceeding.
My lord, if that is so, then he can prefer appeal, my lord. This is the
Lordship,
copy of the
That
copy of
court
the
will
Aadhaar
decide.
card, my lord.
Lordship, kindly ask them to file an affidavit and kindly submit.
We all are the officers of this court, my lord.
Let the voter identity
No,
card,
no, Aadhaar card is Xerox.
let the Xerox of the Aadhaar card as produced by Amman,
Skip it.
is present in court, kept on record. Yes. Yes.
Lordship, a copy of the report may be given to us, Lordship.
Yes, my lord. I am handing over. Yes, now.
Because otherwise,
Next.
Next.
9, I'm for the
For
petition.
state-
Lord, I am appealing for the Union of India, Lord. I'm led by Mr. T. Hey, Union of India, Lord.
9, new matter.
Particularly-
I am for the petitioner, Lord, so I will not say anything.
First time it has happened.
Second time. I am not praising
My lord,
anything right
similar
now.
type of matter, my lord.
Yes, yes.
She is living in my lord.
In their
Yeah,
custody.
what
possibly.
Union of India has to?
Union of India is respondent number 9 and 10.
Yes,
Not
Mr.
raised.
Chatterjee, what is this case?
Bolo, bolo.
They will submit their report.
Pardon?
They will come up with their report.
I have already submitted.
What?
But
Yes, they have
she is residing in her house, my lord.
Where? Whether 164 statement has been recorded or not has to be.
He's a petitioner.
And when police approached her for recording 164 statement, she denied. My lord, kindly
Lordship, this
see
is
the
the complaint I sent against the police on that day that I was taken to the police station. Fortunately, everybody is not the same. Some people sometimes raise their voice.
question.
Yes, with
Apni?
us. Not with your people. This is the complaint I have sent.
আমাকে একটা কপি দাও দেখি কি
No.
কমপ্লেন।
This is the email.
এটা কোন থানা?
Statement.
164 করতে চাইছেন না?
আসেনি, appear করেনি।
I raised the specific complaint that I was told by the police
10, 11, 12 তাই তো?
that I don't want to record my 164 statement, so give the statement like that. My sign was obtained on coercion. Petitioners are present here.
উনি কি 164 করবেন?
Everybody is not the same.
তিনি কি 16 করবেন? 64
Consider করবো তোমাদের হাতে না সিবিআই
এটা সাবমিশন করি। সিবিআই কি ইতিহাস পারপাস পিটিশন যে পারপাস প্রেজেন্ট আছে
She's
কত অরিজিনাল কি আছে?
ইনভেস্টিগেশন করা হলো, কোথায় আছে, আমাকে প্রোটেকশন দেওয়া হবে, সিসিটিভি
আমাকে
ফুটেজ দেওয়া হবে, স্ট্যান্ডিং ইন কোর্ট কন্ট্রোল ইনভেস্টিগেশন আলাদাই
এটা একটা আর একটা কই 164 করতে দিয়েছে
স্টেটমেন্ট
This report you have filed today.
yes my lord original copy is with me my lord
Huh?
entire case diary is with me my lord and petitioner prayed before your lordship to produce the body
Please wait.
my lord
Excuse me.
Who is Sayantan? Who is Sayantan Rai? Who is Sayantan Rai?
The son.
Our son. কি লিখেছে রিপোর্টে গো রিপোর্টটা দেখা হয়নি আমার।
টাইম ম্যাচ করছে না
পাওয়া গেছে ওগুলো সব 156 প্লাস করবে
Now, where is she?
She is with us.
Then Mr. Chakraborty.
She raised a complaint because they said that she went to the police station. She denied to record her statement under 164 CRPC.
You are not on that.
No, that is part of the record, Lordship. This will go in the record. If otherwise that will prejudice other proceedings, which I may bring in future against the police. The police called her in the police station for one recording of 164. We have made arrangement for 164. Then the police said that you write a statement that I don't want to record 164 statement. She wants to record 164 statement. I verified right now.
Page 70.
My lord,
Obviously, this police station should
friend is submitting.
She is present here. She is also present over here, Lordship.
You are appearing for her.
I am appearing
No,
Are you
for
appearing?
her
for her?
husband, Dilip Roy. I am also appearing for her also.
Now then, what remains in the?
Nothing, Lordship. Lordship, that is the part of the record, their report, that they have taken a letter from them.
We will
I
record-
deny the content.
No, we will record that you are willing to record your 164
Yes.
statement. And if nothing is done by them, you will take a.
Yes,
My
that
lord,
action I will
my
take.
lord,
Only that
এবার আমরা 3 নম্বর
appropriate proceeding I will draw against.
my lord, kindly mention one thing, my lord. We have sent notice thrice to her
পেজ নাম্বার 7
for recording 164 statement, my lord.
পেজ নাম্বার
আচ্ছা শুধু ওই আগেরটা ওই নাথকে disposed of করেছো, তারপরে nothing in this order will prevent the petitioner from taking appropriate steps. Competent if so advised that in accordance. The present এবার এটা দেখো, the present petition has been preferred primarily praying for the following relief. সকলে দুইটা কোট করে দেবে। Mr. Chatterjee, learned advocate appearing for the petitioner submits that the petitioner's wife, namely Srima Rai, contested the West Bengal Panchayat election held on 8th of July 2023 as a candidate of CPIM. Stop. She emerged to be successful in the said election. Stop. The petition stop. In short, Srima করে দে। Srima was thereafter being threatened by the members of the ruling political party under the leadership of one Madhusudan Mondal and one Kutubuddin Mondal.
of course
Stop. As such, the petitioner left her residence and went to Puri and was residing there. However, she maintained contact with her family members. Stop. Thereafter, he said Madhusudan Mondal and Kutubuddin Mondal forced the petitioner to lodge a complaint stating that his wife was missing.
রিপোর্ট আছে
তোমার কাছে সব কটা রিপোর্ট তোমার কাছে সব কটা রিপোর্ট পরেরটা
এটা
এটা
Stop. The Srima was thereafter. Srima was thereafter. সেটা বলিয়ে দেন। Srima was thereafter forcibly. Thereafter was being forcibly detained by the said Madhusudan Mondol and the Mondol. Stop. Srima was Srima escaped from such confinement and filed a representation before the respondent number. Representation is it? On 31st of filed a representation dated 31st of July 2023 before the respondent number, before the police authorities. Stop. However, no steps were taken, and as such the petitioner was constrained to approach. Stop. Mr. Chatterjee, learned advocate appearing for the state, however, denies and disputes the contention of the petitioner and submits that on the basis of the petitioner's complaint, Muttab PS case number 1725/2023 dated 27 July 2023 under 360 under section 363 365 was registered, and in course of investigation, the complainant was examined. Complainant was examined. Stop. Complainant was examined. Stop. Srima was recovered from Puri and expressed her willingness to go back to her house accordingly. Stop. Srima also filed a written declaration before the respondent number 8, stating inter alia that she had not been kidnapped and had not been forcibly detained. Stop. The said declaration along with a report. The investigating officer has filed a report before this court annexing the said declaration dated 5th of August 2022. Stop. Let the same be kept on record. So heard the learned advocates. Next brother. Srima is personally present before this court today.
Along with her husband, Dilip Roy. Husband is the
Along
petitioner.
with the petitioner.
Her
Along with the petitioner whom Mr. Chatterjee is representing.
Yes.
Mr. Chatterjee submits that Srima is ready and willing to record her statement under section 164 of the code. But appropriate steps have not been taken by the police authorities. Stop. Heard the learned advocates appearing for the respective parties and considered the materials of the court. Stop. Indisputably, Srima is an adult lady. She is personally. She has any Aadhaar card?
Lordship, she has got the photograph of the Aadhaar card, which
Casted vote in favor of my landed
Indisputably, next per hard stop. Srima is personally present before this court. Stop. She submits that she had not been kidnapped. She has not been kidnapped and or forcibly detained. Stop. She is residing along with her husband, being the petitioner hearing, at her matrimonial house. Stop. In the said conspicuous.
Possibly, she was not forcibly detained. She was forcibly detained. Now she is there.
No, not forcibly detained by the, that is her statement.
No, she is there. She said that she was taken in that Kormo Tirtho by these criminals, anti-socials of the ruling party. That allegation is still there.
না 5th of August যে ডিক্লারেশন দিয়েছে আমাকে জোরপূর্বক আটকে রাখেনি। দেখো 5th লাস্ট 6টা
বলছি অর্ডার ফেস করুন নালে আপনার ওই
যদি একটা লাইন লিখে দেবে
No, on 5th August, he made a statement that none has forcefully detained him.
But those are taken on coercion.
No,
She
no,
does not accept those statements.
no, she has not been forcibly detained.
Now she is not. She was.
She was, that we have already recorded. That she was, your allegation we have recorded.
Now she is.
আচ্ছা ঠিক আছে, all right, we did that. Shrima is personally before this court. Shrima is personally present before this court along with her husband, and they are being represented by Mr. Chatterjee. Stop. She submits that she is presently residing with her husband at her matrimonial house. Stop. In the said conspectus, and as we do not find any material to infer that Shrima has been illegally detained, we are no further interference is called for in the present writ petition, and the same is accordingly disposed of. Nothing in this order will, however, prevent the petitioner from approaching the competent forum if so advised and in accordance.
Grateful, my lord. Lordship, may I get a copy of the record from my learned friend?
এটা তুমি পারমিশন না করবে
কি বলো, and as we do not find any Shrima is personally better follow the in the set follow তার আগে হ্যাঁ Shrima is personally present by Mr. Chatterjee, learned husband at her matrimonial house. In the circumstances system. And as we do not find any material on record to infer that she has been forcibly সেটা তো পাচ্ছি না বলছি। সেটা তো ডিটেন করেনি, ও স্বইচ্ছায় পরিবেশ Your contention, Mr. Chatterjee, was she was being threatened. As such, she went to Puri.
She went to Puri.
But she was maintaining contact with the family.
Contact with the family, but she was under.
Thereafter, police conducted raid and brought her
And kept her in other place.
And
Released.
after the complaint was lodged that Madhusudan and others took him to a separate place and illegally detained. However, she was able to escape there.
And there casted.
We have recorded that. And we are saying that at present she is residing at her husband along with her husband, and there is no material at present to infer that she is being illegally detained.
Yes.
So we are disposing it of, we are giving you liberty to approach.
Yes. My lord, another thing, indulgence, lordship, the report, copy of
Only one copy of the report, my lord. Previous.
Maybe given to us, lordship, I will just.
My lord, in this matter,
In this
Mr.
matter,
Chatterjee, you hand over your copy, keep this copy.
all advocates are Mr. Chatterjee.
no, my lord, I don't need, my lord. Kindly keep.
No, it's okay, it's okay. We have kept it on.
In last two matters, surprisingly, all the advocates were Mr. Chatterjee.
My lord. My lord, in this
Three
matter,
strategies, two
my lord,
strategies.
in this matter, she casted her vote in favor of my learned friend's party.
That's why she is with.
For that reason,
So how
she
you
has
are
no.
concerned? How you are
No, I
investigating?
am not concerned, my lord.
Grateful, my lord.
Concerned?
No.
Covered or not?
Recovered, my lord.
Yes,
By the
yes.
police.
Next.
Your Lordship, in item number 10, conducting advocate is not present today due to his illness, praying only not today, Your Lordship. Just inform.
Yes, my lord, report is with me, my lord.
Where is your address?
Investigation is going on, my lord.
He is ill, Lordship.
আমি কোনো টাইম করিয়ে দিচ্ছি দাঁড়াও টাইমই হবে আমাকে রিপোর্টটা দিতে হবে
আমি কপিটা নিয়ে ওনাকে দিয়ে দেবো।
Have you recovered?
নো মাই লর্ড এই আরেকটা
What is the age of the girl?
মাইনর মাই লর্ড
You have registered any case?
Yes, my lord. Case has been
What
registered.
your police is doing?
Police is proceeding has been initiated, my lord. Police has started case, my lord. Police went to the
When
spot.
started case?
My lord,
when
kindly,
did the
my lord,
police
kindly
start?
give me some time, my lord. Just now I have received the copy. তোমার ইয়েটা দাও যেখানটা আমি লিখেছিলাম রিটটা আমার
Have you served upon all? Have you served upon all the respondents?
Yes, I will. সবাইকে সাথে yes, Your Lordship.
Where is yes? Where is the affidavit of service?
Your Lordship, the advocate on record is not well and all the documents is with him. I am only seeking not today, but I believe he has served all the parties.
Private respondent.
My lord, he fled away with the private respondent, my lord. Police have started investigation, my lord.
Have you registered any have
Yes,
you
my lord.
registered any
Case has been started under section 363, 365 of the Indian Penal Code, my lord.
Yeah, March, in the
And
March.
FIR has been started on 20th March 2023. Her IMEI number was also analyzed, my lord.
You completed, you lodged the complaint in March,
On
She
to-
looked in March only.
March 2023. Until date, you have not been able to
No, my lord,
recover.
police is doing their job, my lord, sincerely searching him. He,
Uploaded her details
How
in
since
we have uploaded her details in the portal of the police and investigating agency
have you
intimated.
arrested them? Have you arrested
No, no,
them?
he, that boy is with her, private respondent. Both are fled away, my lord. They have a love relationship.
Very good. Who is Shambhugiri, the father of the boy? Respondent number 7.
Father of the boy.
So from March, the father was not approached by your investigating officer?
Yes, he was approached, my
Where?
lord.
Where have you stated approach? Where have you stated?
My lord, kindly allow me some time, my lord. I have just received the report.
এত sincere. What is the statement of Shambhugiri? Have you recorded his statement?
My lord, kindly adjourn the matter for 2 days. I will place the case diary also.
Monday. Yes.
May I get a copy of the report?
No,
No. You asked your investigating officer, we want result. From March, she is eloping and you have neither questioned the father of the girl, boy.
my lord, state.
For 7 months, you did not get time to go to his house and record his statement. We will appropriately deal with your officer. You
My lord,
better advise him.
My lord.
Yes, next.
But 11 onwards till 15, my lord, similar matters for extension of interim order. The interim order was first passed on 8 June 2023, my lord.
I am for the writ petitioner. Well, I am appearing for the state respondent, my lord.
Kindly seize the order dated 8 June 2023.
Is for the state?
I am for the state respondent, my lord.
To Debrai on virtual mode, my lord.
I am
As-
appearing for the state respondent, my lord.
Right.
Kindly seize the order dated 8 June 2020. May I place my order?
8th June.
Yes. After hearing the may I place my?
Let us get
Acha,
the order.
acha.
8th জুনের অর্ডার কোথায়? 8 June.
May I place?
No, we are reading. With you contested the selection process.
No.
No,
We are the successful persons who have been working from November, and well, kindly seize the second paragraph. My contentions have been recorded. Learned counsel appearing for the appellants made elaborate submissions, various submissions on merits, appellants, and submits that the selected candidates who are engaged on contractual basis, that is my clients, the appellants
That selection, there were 2000
posts.
posts, out of which 1878 were selected.
Yes.
You are amongst them.
Yeah, amongst them. We were not parties.
You were working.
Yes. Yes.
Thereafter, the selection process was challenged by him.
Him.
Yes.
He was a participant in the selection.
Yes. Yes.
So he challenged the selection. Learned single judge said that
Was
you
Enter selection process cost
will enter selection process or fresh selection process will
to be initiated. Yes.
they will continue till new incumbents are appointed.
No. We-
Come to page 2.
Of the order.
Uh,
Yes.
by order dated 3rd May, single judge disposed of the writ petition.
Yes.
Yes.
Therefore, this court directs that the selection process for the post of Bonoshoyok will be freshly conducted within a period of 2 months from the date on the basis of the eligibility criteria and in terms of the selection process advertised on such and such within a period of 2 months from the date. C member CEB will conduct process. The selected candidates from the list of eligible candidates will be published in the official website. The engagement of the underaged candidates shall be terminated upon completion of the process for Bonoshoyok within a period of 2 months from the date of the previous extension granted. So our appointment goes. Our appointments were cancelled.
Of the selection process within a period of 2 months from date.
Yes.
The previous extension granted to the candidates means your clients.
No.
our previous extension.
But Lordship is reading where, my lord?
Next para 43.
Oh, next para, next.
Will be
Upon completion of the new selection, Bonoshoyok,
Yes.
within a period of 2 months,
Yes.
the previous extension granted to the candidate, that is your client,
Will terminate.
will be terminated.
terminated.
So our service goes,
The newly selected incumbents will come and join.
we challenged.
You challenge. Now they have just a moment.
Paper book দেখাতে হবে না।
So the fresh notification was stayed
Yes.
and the writ petition is still pending.
No, no.
No, disposed of.
Writ petition disposed of by this order.
After disposal, my lord, the state took up, advertised the new notification. They received the applications and thereafter the stay was granted.
Now paper books have been
Yes,
filed.
yes.
Yes, yes.
Huh?
Paper books
Yes, yes.
ready.
Ready.
It has been extended on 2 occasions. Miss kindly sees the next order of extension.
Where is the
This
paper
is
book?
the paper
filed?
Paper book, my lord.
All
with
paper
task, my
books.
Uh-huh.
Paper book. with
All
task.
matters.
All matters. Paper.
This is the first
Wait,
paper
wait,
book.
এই জয়ন্ত,
আমাদের পেপার বুক গুলো আনতে বল।
ষোলোই আগস্ট দিছিল।
Now, my lord,
Yes, what years have?
My lord, on
Paper books are ready.
Yes,
We
madam.
are fixing the.
fix it,
Yes,
fix, yes,
my lord, your
yes.
lordship had fixed this matter on 8th of August to be heard of.
August, yes. Lordship was not available, the
Well,
bench
11th
was not
of
available, so
July,
therefore.
11th of July, your lordship. Lordship kindly fix the matter
on Yes.
any of the day on September. That is better, madam. September, any of the day of September.
Holidays.
My lord, kindly. my lord.
Daughter,
September, my lord, next. This is the entire list. 11 matters are there
There are
against these.
there are
5 matters are there before your lordship today. There are other connected
Madam,
matters are also some appearing in the list.
in the
Madam, your
morning I
lordship had
mention,
asked
my
me
lord.
to
First
submit
matter
the-
in the morning I mention, my lord.
My lord, your lordship had
Why
heard
separate candidates file separate?
Separate
appeals against the
sets,
same order.
separate sets, separate advocates.
Separate division. My lord,
Separ-
there is a separate division, that is why, my lord. My lord, lordship had asked me to provide the numbers on the last
My lord,
occasion.
may I file the paper books, my lord?
আর নেওয়ার জায়গা নেই সেদিন।
না, রোজ ক্যারি করতে হচ্ছে।
জয়ন্ত অন্য ইয়েগুলিকে তাহলে ওই একটা দিনে fix
We were not finding the regular bench so that we were not being able.
advocate
May I
appearing
just
for the
indicate the
respective
item numbers where the interim order is there? And the other connected matters which are appearing in your lordship's list, fresh matters.
in which no order was passed.
No order was passed.
I don't know, 15.
Item number 15, there is no interim order.
করে নাও।
That is a fresh matter.
সবাইকে খবর।
15 is, no,
Release.
supplementary, supplementary.
It has been stayed, na? They
Yes,
did not
yes,
follow.
that is what I'm saying. To be tagged,
Na,
Notification has been stayed. Yes.
tagging. Analogous hearing.
which is the matter?
15, item number 15 and monthly list কত number?
My matter not in the list.
223 to 227.
That 991. First
Fresh
matter.
matters.
Fresh matters এ তো
15,
wait.
Huh.
Let tomorrow some matters are coming. Tomorrow it was mentioned some
আর একটা কি আছে 1037 1037 all this matter have been stayed.
ওই তিনটে সমেত ফাইনাল হিয়ারিং এ ঢুকে আছে।
মানে kindly fix a date মানে for hearing.
It's appearing for the respective parties.
paper book গুলো নিয়ে নিন। Paper book.
We have been informed that paper books have already been prepared and served, and the appeals are ready for final hearing. In view thereof, list the appeals for final hearing. In the combined monthly list of September, September 2023. Stop. The interim order passed earlier is extended till the end of September.
End of September.
deep level is on.
One paper book, my lord, may I file the main matter?
ওটা তো দিতে হবে। সেটা আমরা কোর্টে অন্যগুলো আসুক ওই হ্যাঁ till the end of September 2023 or until further orders whichever.
My lord, would your lordship pass the
End of September.
Well, would your lordship extend the interim order till the first week of October? Because there are some holidays I see on the second October is a holiday. So
It appeared in the combined list.
I will mention.
You
It is there.
mentioned we will upgrade and
Yes.
fix the date.
Yes. And my lord,
the
I
order-
propose rather to my lord to cut short this heavy my lord dumbbells. I propose to make a short my lord convenience brief, so that all the papers are compiled in one convenience brief and the paginations will be given where this has been annexed, say in the writ petition or in the affidavit in opposition. Your lordship will only handle that.
এক second file টা দাও।
একবার দি-
applications, what are stay applications are, we can dispose of this.
All,
stay.
all,
Yes.
all
The applications I think disposed of now.
disposed of.
We had filed vacating application.
Oh, leave to appeals have been disposed of. Yes, stay applications may be disposed of. Yes.
এটাই তো বলছি, how disposed of? It was
No, not disposal.
But
Leave
leave
to
to
appeal has
appeal
been
disposed
disposed
of.
of. There were two applications. Since we were not parties in the writ petition, we have filed a leave to appeal and a stay. না, একটাই ফাইল করেছি।
না আমরা দুটো ফাইল
দুটো ফাইল
লিভ টু অ্যাপিল এন্ড স্টে অ্যাপ্লিকেশন।
Yes.
item number 11, what is can 3?
But we had filed a.
Can is the vacating application.
Vacating application.
দে ফাইল।
Can 2's would be the stay application.
Separate order.
In item number 15, there is a section 5 application that may be disposed of.
না না আমারটা লিস্টে নেই, আমারটা 991 ম্যাট।
Stay application will dispose of main matter.
কিন্তু সাবমিটটা ডিসপোজ অফ করছি না vacating এ।
অ্যাপ্লিকেশন ডিসপোজ অফ হয়নি।
Leave to appeal হয়েছে।
আমাদের অ্যাড করতে দিই।
Are you contesting the vacating application or we dispose it of?
Disposed of. But since your lordship is fixing a date for here in
Basically
the monthly of
expeditious,
September, it can be disposed of. my lord.
পেশার দেওয়ার জন্য করেছি।
What is in 15 can number 3 is
That is the section 5 application. That is a fresh matter where there is no interim order.
then why it has been listed?
It's
for
erroneously
extension? I mean,
listed. I think the entire list has been given, so therefore it has been listed.
in 994,
994, there is an interim order.
so
This-
why, what is can 3 in 994?
Vacating application. Vacating application.
It is our application. my lord. That can be disposed
So
of.
why you are saying section 5?
In item number 5, there is a section 5. 15, sorry.
In item number 15,
It is a fresh matter. There is no interim order.
then how that was tagged with that?
It's wrongly tagged, my lord.
সেপারেট ম্যাটার।
1312 Mat 994, 995,
996,
996.
1008.
এগুলো একটা ম্যাটার। এই 11 থেকে 14 পর্যন্ত অর্ডারটা হোক, আর বাকি কালকে
হ্যাঁ, না 11 থেকে 14 ক্যান 3 টাও ডিসপোজ অফ করে দিই।
প্যাকেটিং অ্যাপ্লিকেশন।
ডিসপোজ অফ করে দাও ডেট
From 11 to 14, can 3 may be disposed of. These are vacating applications, and can 2 is the stay application.
ফার্স্ট অর্ডারটা ওটা কেটে দাও, কেটে লেখো ফার্স্ট অর্ডারটা হবে ইন রেসপেক্ট অফ আইটেম নাম্বারস 11 to 14. 26 is 26
এটা কার ম্যাটার? এটা হচ্ছে লিভ টু অ্যাপিল এ সেকশন।
এই করতে করতে আমাদের পুজো এসে গেছে।
And what is this application in item number 14, can 1 and can 3?
Can 1 is the item number 14. Yes, can 1 is the leave to appeal, and can 3 would be the vacating application.
In 14 also.
In 14, they have preferred vacating application in all where the writ petitions are there.
Can 1.
So application again.
Can 1 is the leave to appeal which has been disposed of.
Disposed of.
Yes.
Can 1 to dispose of এগুলো আর দেবেন না?
Item number 14 is MAT 1008, where kindly sees the order. First part is disposing of can 1. After hearing the learned counsel affirmative authorities, we grant liberty to applicants to present the appeal. This officer's directed application for leave to file appeal is thus allowed.
Application 3.
Vacating the distance
এখানে আছে আর এখানে আছে 11 আছে 11 13 আর 14 না 12 তেও আছে হ্যাঁ সব করেতেই 3 হয়ে গেল
vacating is to vacate or date for hearing. Vacate and hearing or dispose of it. কি লিখেছো? টার্গেটটা কি লিখেছো? Is the list the appeals for final hearing in the very supplementary list of this court on 25th September. On 25th September.
26th September daily list.
On 25th September, stop the interim order passed earlier is extended. Stop. No, the report. All the above appeals have been preferred against an order dated 3rd May. All the appeals have been preferred against an order dated 3rd May 2023. And as such, the same you file leave to appeal application
Yes.
in some, and in the others
All leave to appeal.
all.
Because we were not parties in the writ petition, so we had to file leave to appeal. Those have been allowed. And the stay application, this order has been passed. Kindly sees the first paragraph of the.
all the appeals which are here in the list which has been filed,
Yes.
the other matters which are not appearing,
Yes.
in those also leave to appeal was
Yeah,
filed.
yeah.
Yes.
All appeal.
11 to 14 already interim order. 15 is a fresh matter, and thereafter in monthly list item numbers.
Then we do one thing, we dispose of all the applications, we dispose of the application and we extend the interim order till the disposal of the appeal,
But then, my lord, there's a possibility, my lord,
and we fix the matter on 26th.
but can it be sometime earlier, my lord?
Prior to that, it cannot be. Now, if you say if you want to press your vacating application, then we have to again hear it.
Kindly fix up for final hearing, my lord. There's a short point involved, my lord.
না ওটা তাহলে combined mistake থাকবে 26 তে করে
হুম?
দিতে হবে। এটা তো extend
ও।
application সমেত তাই শোনা যায়।
ওগুলো ঠিক কি হবে একটা লিস্ট দিয়ে দেওয়া হয়েছে তো।
তাহলে
Kindly keep
দেখে
it in
নিচ্ছি,
monthly
আমার
list করে।
পড়বার জন্য।
আগের অর্ডারটাই থাকবে। Are the learned advocates, we have been informed, না, we have been informed that the paper books have been filed and served and applicationটা তো মধ্যে dispose of করে দিতে হবে।
কোনটা আমাদের এর ভিতরে?
তুমি আনিয়ে নাও নাহলে আমি বিপদে পড়ে যাবো।
নেই লিস্টে।
ঠিক আছে, thereof
ঠিক আছে, ঠিক আছে।
in the daily supplementary list of this court on 26th September.
আবার ভুলে গেছি।
Stop. The interim order passed earlier is extended till the end of September or until
প্রথম
further
order টা
orders whichever is there. Yes, next.
26 সেপ্টেম্বর।
Paper books have not been filed.
11 থেকে 14 হলো
We
তো।
have not been, we have not stated file. We have said we have been informed,
Served.
prepared and
PPF.
served.
11 থেকে
Ready to
14
file.
আপনি করে দিন। 11 থেকে 14 করে দিন।
15টা এবার দিচ্ছি। 11
টা আজকে চলবে।
নিতে চাইছে না, নিতে চাইছে। May I file one paper book? Main matter. Item number 15.
এখনো কোনো অর্ডার পাস করা হয়। ফ্রেশ ম্যাটার।
This is 1 to 14, তাই তো?
কনভেনশন করতে হবে। আর
না,
যে
এখানে
ম্যাটার
leave to
গুলো
appeal আছে।
কালকে করে কালকে করে।
কালকে শুনুন। Item number 15 will appear along with the other matters tomorrow.
Yes, oh, tomorrow. But tomorrow it is a fresh matter. There is no interim order in this.
In the matters which are appearing, those are also, I don't know
No,
whether,
on those matters, interim orders are there.
let us see, we'll check up and pass the order.
Yes, then item number 15, monthly list 223, 226, 227, 228.
এটা 21 তারিখ করে দাও, 21st September. 21st
আবার উল্টে
September.
গেল। কতবার
21st September, interim order till 30th September.
Supplementary list of this court.
Grateful.
Yes. Yes, next. 16.
বাদ বাকি তোমার সঙ্গে কালকে দেখা হচ্ছে না। আরে ও অনেক ভালো ফোনকের মতো কেউ ছিল।
Yes.
16, 17.
Lordship, in item number 16, your lordship, Mr. KK Maiti is appearing, your lordship. Due to some personal difficulty, he could not come today, your lordship. I'm just praying for not today, your lordship. Only
This
not
is-
today.
This is fixed for the purpose of
Lordship, due to some personal difficulty, he had an interview today, your lordship. For that reason, he could not come.
Next
Just not
Wednesday.
today, your lordship.
Next Wednesday. Yes. Come.
I'm grateful, your lordship.
page. Milord, could it be made not Wednesday, some other day, Milord, subject to my lord's pleasure? Because this is for final disposal, your lordship will hear the matter and dispose of the matter. So any day that other than 23rd, Lord.
The problem is that I won't be here. I will be going to the circuit. Then it will be in the second week of September.
No, then, Milord, earlier, Tuesday,
not
subject
possible.
Tuesday, Milord, or this Friday. Because I'll hardly take 15-20 minutes of your lordship's time.
All right, you come on next Thursday then, 24th.
24th, lordship. I'm getting in the supplementary list, Milord.
Grateful.
Don't take adjournment on that.
No, your lordship, but just for today.
Last time also they didn't come. I presented the matter.
চলো উঠে যাই তারপর combine
I'm grateful.
ডেকে দাও।
Your Lordship, may I be permitted to mention? A few analogous matters were directed to be listed today, Your Lordship, but they are not appearing in the list.
There are 20 analogous matters.
11, Your Lordship, 11.
Did we say that 11 will be heard together?
No,
11
one,
matters.
one matter was heard on.
You were my officer was confused. He said that one matter was fixed, but you gave the mentioning slip along with 10 other matters.
No, your lordship.
Yes.
5 matters were listed on 9th of this month, and rest of the 5 matters were to be listed. I have ticked those 5 matters only. Not the rest of the, they were already in the list. They were
Which are
already
in the list.
on 9th of this month, your lordship, 9th August. And it was not heard due to the adjournment taken by the Learned Council of the Railway.
Who is your other side?
Mr. Maiti. Mr. Maiti, senior counsel,
Then you
representing
do
the
one
railway.
thing, give a notice to Mr. Maiti, as that day it has not appeared. On Monday, you remind us, we will fix all the matters on a particular day. All right.
Yes, sir.
On
I
come and
promise.
you give a notice to Mr. Maiti and you come and mention before us on Monday.
Obvious.
So
And
that in his presence, we can fix a date.
order is also not available in the website, your lordship. On the last occasion,
Cannot,
on
সেটা
9th
কেন?
of August.
9th August, it
Yes.
is not there.
No, your lordship. And the poor workers are willing to come, your lordship. For the second time, they are willing to come, but I stopped them because it was not appearing in the list.
সার্ভার হয়নি আমরা অর্ডারটা কি হচ্ছে বুঝতে পারছি না He will check up and kindly remind us on Monday.
Yes, obliged.
Yes.
My lord, I'm for the petitioner. I'm praying for not this week, my lord.
Go out of list.
No, my lord.
People are not interested.
No, my lord, our clerk has changed, so filed is somehow misplaced, my lord. So kindly,
What is
please,
the application? What is the application?
my lord, I am not aware of this case.
Who is your senior?
KBS Mohapatra. He is appearing in this case.
ইয়ে করে দেবে,
Kindly,
করে দেবে, it will after the list is called. Yes, next.
My lord, 174 টাই আমাদের। My lord, 174, my lord, state is the appellant here. My lord, so far I am concerned, my lord, the difficulties, my lord, from since my lord, morning, my another appeal is going on. My lord, court number
Who is
12.
your other side?
My lord,
My lord, Mr. Abhishek Prasad is appearing behalf of the petitioner, read petitioner.
No,
Respondent.
why it is under application head?
No, my lord, the appeal is ready. Paper book, my lord, already, my lord, submitted. Appeal is ready. Appeal is ready for hearing. There is no question for any interim order. My lord,
Then
Kindly, my lord, fix a date, my lord.
70.
For hearing.
Yes, we go on fixing dates and on every occasion adjournments are taken.
No, my lord.
দেখি 174 টা দাও।
না না এটা তো ডেট ফিক্স হবে হিয়ারিং এর জন্য।
অর্ডার শিটটা দাও।
ডেট ফিক্স হোক হিয়ারিং এর জন্য।
এটাকে কম্বাইন্ড লিস্টেড ট্রাইব্যুনাল অ্যাপ্লিকেশন হিয়ারিং এ পেপার বুকস হ্যাভ বিন ফাইলড।
Yes, my lord. And also exchange between the parties.
কোনটা আছে? হিয়ারিং গ্রুপ 6. It will appear next combined list hearing groups.
Grateful.
Grateful, my lord.
এটা করে দাও, আমি স্টেটের হই আর তুমি এনবিএসটিসি হই।
I'm for the respondents.
You're for the respondent. What is the application about?
Similar in this matter, Senior Counsel Kumar Jyoti Tiwari is on like is coming.
What is the application for?
অ্যাপ্লিকেশনটা কি আছে ফাইলে? দেখি কি সুরজিৎ কি আজকেও আসেনি? কেন কি হয়েছে? আইপির ঘরের শর্ট হিয়ারিং।
That's why interim order. Restitution order takes place.
You are there, Mr. Majumdar.
I am for the appellant. File about file.
Yes, tell us what is the
concurrent finding of misconduct.
You are kindly pass over the matter. As Senior Counsel is on like.
why the stay application has not been disposed of?
Disposed of.
It has not been disposed of.
Yes.
Yes, place the matter. You are not ready?
Hello, yes, I am placing.
Yes, please.
Hello, there are two charges against me, charge 1 and charge 2. In respect of charge 1, I was held not guilty of the charges and I was exonerated. Only I was held guilty in respect of charge number 2. Lordship, kindly come to charge number 2, page 27. My lord, sorry, my lord. Lordship, memorandum is annexed to P1. Lordship, kindly come to page 11 of my stay application. Page 11 of my stay application.
Yes.
Charge number 1, my lord, was not proved and I was exonerated. Now charge number 2. What is the charge, my lord, against me? Number such and such, Head Constable G.D. Ramdayal Rai of CISF unit, Kolkata Port Trust, Kolkata, was detailed in SCF duty on such and such date from at hours to at hours at NSD guest number 9 along with ASI X Prasanta Kumar Pramanik on 24th February 2013 at around 12:30 hours with Tata Magic vehicle, registration number such and such reported, which was allowed to exit from the gate without proper checking. This is the only charge. Without proper checking. Immediately the said vehicle was stopped outside the gate by Head Constable S. Gupta and Head Constable GDSP Gupta, both working in CLW, and found that the said vehicle was carrying 20 items unauthorized without any valid pass permission. The seizure list was prepared and FIR was lodged with local police, such and such. The above act on the part of the Ramdayal Rai amounts to gross misconduct, dereliction of duty, or negligence, an act of unbecoming of a member. This is the, my lord, the charge against me. Second charge. On the
যেটা আনতে বলো তো লিখ দি
on the basis of the said second charge, my lord, the inquiry proceeding was held, and the inquiry officer was held me guilty of the charges. Thereafter, my lord,
but
the disciplinary authority was imposed punishment.
But all these are in Hindi.
My lord, I am giving your lordship the translation.
You have prepared the translation?
The translation.
You have checked up translation?
If he's with senior Mr. Kumar Jyoti Tiwari, so kindly make it not.
You are his junior?
Yes, my lord.
Have you seen the translated copy?
No, I have not seen.
This is not translation by our department. It is your translation.
Yes,
Huh?
Department.
Department translation. I see. Where is your senior?
He's on like it is another court.
Sit down and take notes and ask him to come. Yes.
My lord, my submission before your lordship, although my lord, the inquiry officer report was not annexed with this stay application, but my lord, the inquiry findings of the inquiry officer is vitiated in law due to certain illegalities and irregularities. I will come later on. I have also translated the findings of the inquiry officer report. I will come later on.
The inquiry
at this stage, my lord, for the purpose of my lord, the allowing the stay application, my lord, I am.
No, stay application, nothing remains, Mr. Mojumdar. The entire appeal is to be heard.
Is to be heard, yes.
There is no scope for any interim.
Stay, no scope of interim order. But appeal will be heard.
Then you kindly prepared a paper book incorporating the translated document.
Yes, yes. My lord, including the findings of the inquiry officer, that is also to be required to be included in the paper book. Because my lord, this is a transfer brief. It is not prepared by my office. That is why the difficulties arises. Only the disciplinary authority order, punishment order, and the appellate authority order. But both the two order, my lord, will go because the charge which was against me, they, my lord, found me guilty in another allegation, which is not the scope of the charge.
What was the punishment imposed?
My lord, I was punished with compulsory retirement of 80%
Pension.
of 80%
Pension.
pensionary benefit. Appellate authority modified the same and he passed the order that he would be entitled to get compulsory retirement with all the pensionary.
The present appeal has been preferred, challenging the judgment dated 16th of January 2020, passed by the learned single judge in the writ petition being WP number 29124 bracketed W of 2014. Upon hearing Mr. Mojumdar, learned advocate, appearing for the heard the learned advocates appearing for the respective parties. Stop. There is no scope for issuance of an there is no scope for issuance of any interim order in the present appeal. Stop. We have been informed. There is no scope for issuance of any interim order in the present appeal. Stop. And as such, the same is pension person pension ওটাকে তুমি কি করে করছো না ফাইনাল অর্ডারটা অ্যাপিলেট অথরিটির অর্ডারটা দাও
বললো তো পুরোটা দিয়ে দিয়েছে।
Where is the appellate authority order?
My lord, that is, my lord, annexure P4, page 27.
Yes.
Page 27.
Operative part. Yeah.
Actually, there is no scope for issuance of an interim order in the present appeal. Stop. Mr. Nixper, we have been informed that the in scope for in the present appeal. Stop. The appellant is directed to prepare paper books incorporating the pleadings exchanged by the parties.
Incorporating, my lord, the translated copy of the
Incorporating the pleadings exchanged by the parties in the pleadings exchanged by the parties in the writ petition, together with other documents and translated copies of documents as placed as and other documents strokes translated copies upon which reliance was placed before the learned single judge. Stop. Please the appeal for yes.
My lord, within a period of
incorporating the pleadings exchanged by the parties in the writ petition. Okay. The translated copies, the translated copy of what you want to place.
well, translated copy of the findings of the disciplinary authority, the order of punishment. Lordship kindly come to page.
Findings of the inquiry officer was written in English or Hindi?
Findings of the inquiry officer is not also in Hindi, but I have translated in English.
Exchanged by the parties in the writ petition together with translated copies of the documents
Written in
pertaining to the disciplinary proceeding. Pertaining to the disciplinary proceeding. Stop. Let such paper books be filed within 4 weeks with copies to you are appearing for all.
Yes,
with copy to the learned advocate appearing for the with copy to the learned advocate appearing for the respondent. Stop. The application for stay. The list the appeal within a period of with copy within a period of 4 weeks from them. Stop. List the appeal for final hearing in the combined monthly list of October 2023. The application for stay being there is no scope for issuance of any interim order. তুমি কি বলছো? And as such the application for stay and as such the application for stay is disposed of without any order. Without any order.
application কোনো order তো পাস করছে না।
And as such, no order is no further order and as such, no order is required to be passed in the stay application, and the same is accordingly disposed of. তারপরে ওই paper yes, next.
Hearing of the appeal will be placed on monthly list of
October. Yes.
My lord, I beg to appear on behalf of the appellant in this matter, my lord.
What are the applications?
My lord, it is a condonation for delay of 9 days. 9 days, my lord.
You're opposing, Mr.
I'm for the respondents, madam.
You're opposing section
madam.
5. Section 5.
No, section 5 are not opposed.
That is section 5 is
Can, my lord, this is 1.
And one.
Can 1 is the section 5, my lord.
Stay of operation.
yes, and the other one is for stay of operation.
Stay of operation. My lord, may I draw your lordship's attention to the order impugned first? That is dated 12th of January 2021. Matter pertains to compassionate appointment.
Can 1 your section 5 is can
1, my lord.
Can 1. Upon hearing the learned advocates appearing for the respective parties and upon considering the averments made in the application for condonation of delay, we are satisfied with the explanation given towards the delay in preferring the present appeal. Stop. In view thereof, the delay in preparing the present appeal is condoned and the application being can such and such is disposed of. তারপর একটা লিখবে can 1 বলে স্টেট আর can বলছি ওটা বলছি yes
my lord. This matter pertains to compassionate appointment. My lord, the order impugned is dated 12th of January 2021. My lord. My lord, may I place it before your lordship?
Your compassion prayer rejected.
Yes, yes.
So what stay application? What is the stay you want?
My lord,
There's no scope for issuance.
yes, only one thing, my lord, because it is in the Eastern Railway, they have their specific rules and procedures to give compassionate appointment because the posts are filled up by the subsequent applicants. Now it is filled up, my lord, then there will be no vacancy for me for consideration. That is why, my lord, I have prayed for this stay of operation of the year, and one post may be kept vacant.
Your entitlement is not there. You are
No, my lord, I'm
wanting one
entitled.
post
My lord, I'm entitled as per the rules and procedure and the honorable.
Then place the
Yes,
main
yes, yes, yes,
No
yes, ma'am.
further document is
No,
required.
no, not required, my lord. Everything is on record.
Did you exchange affidavit there in the writ petition?
No, my lord. There is a order. There is an order of rejection. It contains everything. So, my lord, it can be, my lord.
So you do not intend to bring any material on record?
No material on record is, my lord. I do not have. Everything is in this application, my lord.
Yes, please.
Yes, my lord. May I place the order impugned at page 65 of the stay application? The petitioner seeks compassionate employment on account of the death of her father, which was rejected by the Eastern Railways. The ground for rejection is that the pension and terminal benefit paid to the deceased, which was received by the family, cannot render the family in destitution or penury. Yet another fact brought to the notice of this court by the Learned Counsel for the Railways is that the son of the deceased is well and sufficiently employed as an assistant sub-inspector of the West Bengal Police. The other two daughters of the deceased are married. It is now well settled that compassionate employment is not a normal process of employment and an exception to the same. It is available only to prevent the family of a deceased employee from falling into destitution and penury. Admittedly, the deceased wife is receiving 25,000 rupees or thereabout as pension. The petitioner is the only daughter who is without employment or support in the family, as argued by the counsel for the petitioner. This court is of the view that the mother is quite capable of taking care of the daughter's interest. Para 9 of the decision of the Honorable
Just a moment. You had 3 daughters.
2 daughters, 1 son.
So both of them are married.
Married. But
So the married daughter is seeking compassionate appointment.
married daughter is seeking compassionate appointment. But my lord, I have stated I will place the documents which shows that.
Now, then the petitioner is the only daughter who is without employment.
Yes, because I stay with my mother and my husband. That I have stated. The applications I will show before your lordship. The documents I have informed the authorities. Now, my lord, may I just place the judgment, my lord. Para 9 of the decision of the Honorable Supreme Court in the case of State Bank of India and others versus Surya Narayan Tripathi reported in 2014, 15 Supreme Court cases 739 is set out herein below. Para 9. In all the matters compassionate appointment, it must be noticed that it is basically a way out for the family which is financially in difficulties on account of the death of the bread earner. It is not an avenue for a regular employment as such. This is in fact an exception to the provisions under Article 16 of the Constitution. That being so, if an employer points out that the financial arrangement made for the family subsequent to the death of the employee is adequate, the members of the family cannot insist that one of them ought to be provided a comparable appointment. This being the principle which has been adopted all throughout, it is difficult for us to accept the submission made on behalf of the respondent. In view of the aforesaid and the facts of this case, the argument of the petitioner that the railway rules with regard to compassionate employment do not specify the assessment of the income of the family, and hence the petitioner is entitled to employment as a matter of right, cannot have any legs to stand. For the reasons stated herein above, the writ petition shall stand dismissed. So, my lord, before showing the order impugned passed by the department, my lord, I just point out few things that my case has been rejected on the ground first that I receive, my mother receives, not I, my mother receives death benefit in terms of the pension and one-time lump sum amount.
What's that order first?
Yes, my lord, kindly take, my lord. Kindly, my lord, take page number 47 for once. Page 47 is the order passed by the railway authorities. My lord, the operative portion is in the inverted commas.
Page 47.
Page 47, my lord, kindly, for once. The third paragraph is the operative portion. My lord.
No, you place the
Yes,
end.
yes, my lord. Let Nabagopal Tiwari, ex-ASI MDP, expired on 19th of November 2019. Srimati Sondha Tiwari, wife of deceased employee, had applied for consideration of her married daughter's appointment on compassionate ground in Group C category, YDL later quoted above. Since general managers are the competent authority to consider the request for employment of married daughters on compassionate ground, as such, with the approval of DRM ASN, the case was referred to PCPO year for obtaining decision of the competent authority for consideration of appointment on compassionate ground in favor of above named candidate in Group C category, by this office letter of even number dated 11th of June 2020. Now PCPO year, by his letter quoted above, has intimated that the case was put up to the competent authority GM, and after examining all aspects of the case, passed the order as under. I have carefully considered the factual position in this case. The ex-employee, late Nabagopal Tiwari, ex-ASI MDP of Asansol Division, expired on 19th of November 2019 at the age of 58 years, 11 months, only about 13 months prior to his normal superannuation, leaving behind his wife, 2 married daughters and 1 son. An amount of rupees 25,05,135 has been paid to the widow of the deceased employee as settlement dues. She is also drawing family pension of rupees 25,250 relief per month and residing in her own house. Moreover, the only son of the ex-employee is working with as ASI West Bengal Police. In view of the fact that there is no financial distress to the widow and no dependents for the married daughter to act as breadwinner of the family, the claim for compassionate ground appointment of Srimati Joyashree Tiwari, married daughter, is not justified and regretted. This is for information and necessary action, please. The decision of the competent authority may be communicated to the applicant accordingly. So, my lord, primarily on 2 grounds, I have been rejected. One being the married daughter, and second that
No, married daughter they have not. They have considered.
yes, on the ground
that the husband had about 13 months of service left. Fourth, his pension amount was received. Second, that was third was you are having your own income, your own house. Fourth was your son is also employed.
My lord.
And as such, the married daughter cannot be construed to be the only person fit to earn a family.
Yes, my lord, in my respectful submission that the first point is that the remaining.
So it was not only on the
ground of. Not only on one of the grounds. One of the grounds was married daughter, and my lord, the rest of the ground.
Son is residing with.
No, that I have informed with the that I will be placing. My lord, kindly give me just some moment, my lord. My lord, first issue is that the 13 months left is no ground as per the rules and notifications. It is no ground that 13 months, if there's left, then it cannot be given. One. Secondly, there is no distinction made in the notifications pertaining to compassionate appointment regarding married daughter or unmarried daughter. It says only daughter. So for the regulations of the railways authorities are concerned, there is no distinction made at all.
It has not been dismissed on the ground
No,
of.
one of the grounds. I'm just
Where?
My lord, kindly see from the very first paragraph, I have been referred to as the married daughter. And
your claim was not rejected since you are a married daughter.
No, one of the grounds taken into consideration that I am a married daughter. One of the grounds, because the last paragraph says
a married daughter has to be referred to as a married daughter.
Yes.
So what is the wrong in that?
Yes, very well, my lord. If your lordship takes in that way, my lord, very well, my lord. I am not just placing on that. So, my lord, the issue here, my lord, kindly take page 48 for once. That the person died in cancer. And my lord, kindly take page 48 for once.
48?
Yes, my lord. Just after that, later, a communication has been sent to the authority. My lord, may I place it? I got your letter.
After what?
After this order, the 47, my lord. This letter has been preferred.
After that order, this letter was.
Yes, my lord. That was of
8th of September 2020.
Yes, this is of 30th of September 2020.
The applicant.
Yes.
Yes, what you are showing?
Yes, the widow mother, sent this letter. I got your letter and it was so unfortunate for me to see that you have rejected my application for the appointment of my daughter on compassionate grounds after the demise of my husband due to cancer. Most distressing was the reason which you have cited for the rejection of my application. I found the reasons very uncompassionate. Since I have already mentioned about my conditions to you in my previous applications about the expenses occurred in my late husband's treatment, I am already broke mentally and financially. The amount of rupees 25 lakhs 5,135, which was paid to me as settlement dues, was not enough. Since I received only rupees 15 lakhs 94,135 in my account, rest 9 lakh 11,000 was deposited into my son's account, who lives separately and is not concerned about me. Also in the year 2017, my late husband met with an accident in which hefty amount of rupees 7 lakhs was spent for the treatment, which we bore from ourselves to help. No help is provided from railway at that time and also at the time of cancer treatment of my husband. I am already broke mentally and financially. My son, to which you have referred, does not live with me and is not in good terms with me. He lives with his wife on his duty place, as I have already said earlier. Then also you have mentioned him in the justification provided. The house in which I have been living does not belong to me fully and is shared with the relatives of my late husband, for which timely expenses are required to be paid for maintenance or shared cost, which is recurring and quite high. Since I am unskilled and mentally not sound, that is why I have not applied for myself for the job. My younger daughter, Mrs. Joyshri Tewari, is dependent on me and she can be my breadwinner if you can reconsider my application. My daughter is married, but her husband is also unemployed and unable to carry the expense. My daughter, Mrs. Joyshri Tiwari, and her husband lives with me after her marriage. My late husband have served railway for more than 36 years with complete dedication. In view of above, I once again pray to your good office to reconsider my request and grant a Group C post to my daughter, Srimati Joyshri Tiwari, so that the long association and memory of the department with my husband is continued unabated. So this was the condition at which the father of the petitioner died in during cancer, my lord. My lord, the moot point of law, which before your lordship today, is whether the death benefit can be taken into consideration, which has largely been relied upon by the railways authorities, that since I am getting that amount, settlement amount and the pension amount, whether that can be taken into consideration. One. And since I have been referred to as a married daughter, presently I am not placing that before your lordship because there is already a judgment of our Honorable High Court of 3 judges bench that is affirmed up to the Honorable Supreme Court that the married daughters are entitled to compassionate appointment.
No,
Now, my lord,
they are entitled.
Yes, my lord.
Subject to proof of the penalty condition.
Penalty condition. That, my lord, I am. That I showed that how.
You have made a statement that I am. Where is your? This is your mother is saying.
Yes.
What documents you have annexed that your what are the statements that your husband is unemployed? He doesn't have a house of his own.
No.
He is residing with the married daughter as a ghorjamai.
Yes.
These facts have to be substantiated, Mr. Laidi.
Yes, my lord.
Mere statement will not help.
My lord, I bow down to your lordship. Only
there was a matrimonial dispute, the daughter has come back.
Yes.
Then
Yes.
you are 2 daughters. Another daughter is
She's
also married. She is not claiming.
No, she's not claiming because all of them have given their no objection. Now, my lord, kindly take the rules. That rules has not been taken into consideration in the impugned order as well as the order of the Honorable Court. My lord, one thing kindly take into consideration, the rule has.
One has given no objection.
Yes, all of them have given no objection that I can place from the record itself.
Now, where in your writ petition you have stated that your son is not residing with
Yes,
you?
yes, my lord. I'm showing to your lordship. That is at my lord. Paragraph 11, page 21 of my writ petition. In this, yes, application. Running page, my lord, 21, paragraph 11.
Paragraph
11, my lord.
That is the representation you have stated.
Yes, my lord, that I have stated in the writ petition.
Where are your pleadings that he has left the family? When did he get the job?
That is not there. that is not. On factually, my lord, on law, I'm submitting, my lord.
Yes.
The rule, my lord, kindly appreciate.
Yes, come to the.
Yes, the rule has not been quoted anywhere, not in the page 47. They have not taken into consideration of the rules of the compassionate appointment, nor in the order impugned before your lordship of this honorable single judge's order. Rules have not been even touched and taken into consideration. My lord, kindly see, even if I, my lord, leave the portion of the matrimonial dispute and that other issues, my lord, the issue of receiving death benefit, whether it disentitles me to receive compassionate appointment, will be clear from the rules itself. My lord, page 50, the rule starts from page 50.
50.
50, my lord. Kindly take the trouble to come to page 50 for once.
11.
These are the circulars, master circulars that of the railway authorities.
Yes.
My lord, kindly take one, that is circumstances in which compassionate appointment may be made. 50, yes. Appointments on compassionate grounds relate to the appointments made of dependents of railway servants who lose their lives in the course of duty or die in harness, otherwise while in service, or are medically incapacitated, decategorized. The circumstances in which appointments on compassionate grounds may be made are as below. My lord, that is the small one when railway servants.
That is not relevant.
Relevant. My lord, kindly take the third after Roman 3. For all above 3 conditions, it writes, compassionate appointments in such cases may be delinked from the payment of settlement dues. In other words, compassionate appointments in such cases may not be denied or deferred only on the ground that settlement dues of missing employees are still to be paid to the persons entitled to receive them. So in 2 conditions, there is serial number 2 when railway employees die in harness while in service before retirement. That is the serial number 2. And for above all 3 conditions, it is categorically stated the rule permits that the settlement dues cannot be taken into consideration. But in my case, your lordship has already been kind to consider that they have referred to my 25 lakhs and 25,000.
Mr. Lady, only on the ground. Rule says only on the ground.
Yes, only on the ground.
Your candidature has not been rejected only on that ground.
Yes, my lord, if not on the ground of married daughter, then at least this.
No, not on the sole ground that you have got retirement benefits.
Yes.
So the rule says
yes
that in these 3 cases,
yes,
it cannot be rejected only on the ground that settlement.
Correct, my lord. But my lord, if your lordship takes the order impugned, it rejects primarily on the ground of my page 47.
Argument.
That I'll be placing, my lord, for once, my lord. Now, my lord, kindly take. My lord, may I just clarify it for once for lordship's kind consideration, page 47 for once. If I may trouble your lordship, kindly take this trouble, my lord, for me to page 47 on which ground exactly I have been rejected. Page 47, the operative portion, my lord. I again trouble your lordship, kindly forgives me for that, my lord. Page 47, that exactly on which ground I have been rejected. May I place it, my lord? I have carefully considered the factual position in this case. The ex-employee late Nabagopal Tiwari, ex-ASI MDP of Asansol Division, expired on 19th of November 2019 at the age of 58 years, 11 months. That is only about 30 months prior to his normal superannuation, leaving behind his wife, 2 married daughters and 1 son. An amount of rupees 25 lakhs and odd has been paid to the widow of the deceased employee as settlement dues. She is also drawing family pension of rupees 25,000 and odds relief per month and residing in her own house. Moreover, the only son of the employee is appointed with West Bengal Police. So, my lord, primarily I have been rejected on the ground of this amount I have received. My son, who is in service, and my lord, these are the grounds. These are the 2 grounds for which I have been primarily been rejected. Your lordships have been extremely kind to consider the rule which says that it cannot be taken into consideration. Even I will be placing the judgments which says that terminal benefits is a deferred payment of the salary benefit of the employee, which cannot be taken into consideration for grant of compassionate appointment, which I'll be placing before your lordship in course of my argument. My lord, if your lordship kindly takes the trouble further to take the rules page 51. That is the second page of the rules, master circular, my lord. If I may.
Yes.
My lord, kindly take serial number 4 at first. When railway employees become crippled while in service or develop serious ailments like heart disease, cancer, etc., or otherwise medically decategorized for the job they are holding and no alternative job for the same emoluments can be offered to them. This is one of the conditions because my father was suffering from cancer. He died of cancer. So this is one of the consideration they have also taken note of, my lord. My lord, the next.
Lady, where in your pleadings you have said that my son obtained the job on such and such date. Since then, he is not residing with me. Nothing you have written.
My lord, because my lord, I cannot develop it today, my lord, with your lordship, but only thing.
Exactly. You cannot
I cannot develop it.
Here,
My lord, only on law I can submit, my lord. The laws.
your contention is acceptance of settlement dues cannot be a ground for this is well settled.
Yes.
This is well settled.
That is the ground I have been
But
rejected.
your case has not been considered only on that ground.
2 grounds.
The rule says,
Yes.
the rule says that it cannot be rejected only on
Only
one
on
ground.
the grounds.
And State Bank of India says that you cannot go beyond the rules.
Absolutely, absolutely. That's
so
what.
under the rules.
My lord, there are 2 reasons I have been rejected. That is the death benefit, and my lord, my son being in service.
You have not been able to substantiate, Mr. Lady, that my son got the job on such and such date. My husband died in 2019. My son got job on such and such date. He is residing in a separate family. He is a married person with his own family.
My lord, from the record,
no pleadings have
page
been
48, my lord, that is page 48. I can only show before your lordship. My lord, that is not. This is one of the factual grounds. And my lord, page 48.
You are asking for compassion.
I understand, my lord, I understand. My lord, page 48, I had shown to your lordship, and my lord, kindly see, the son has also given no objection to this.
Son has to give. Otherwise, your sister will not.
I understand, my lord. So, my lord, this is. My lord, kindly, may on the point of law, if I may satisfy your lordship, my lord, kindly, my lord, only on the ground of the son's employment and staying with the wife, my lord, there is some factual difficulty I cannot just bring in that way before your lordship. That
if you cannot bring, they will jump upon you and take that ground. That is exactly what they have done. Show me from your writ petition pleadings that you have said that my son got job such and such date. He has left my family.
Yes.
He is no longer with me.
That I have, my lord, I mentioned in paragraph number 11.
There is the representation.
No.
11 is states about the
Representation, right.
Representation was submitted after your case was rejected.
Yes. My lord, kindly give me a moment.
Yes, we give you 5 minutes.
Paragraph 17, I have written that, my lord, the widow and mother and the sister have no permanent means of earning their livelihood, and the petitioner's employment on compassionate ground would have helped the family to pass through such difficult times. That is what I can find, my lord. Lord,
yes, Mr. Lady.
This is on factually, my lord, I cannot satisfy lordship. It is not there. It is not written, my lord. But for on that ground, my lord, I may not be at this distress condition. My father was a cancer patient, my lord. On law, it is well settled, my lord. That I can satisfy your lordships. My lord, this is on factual, small factual ground, whether my brother lives with me or takes care of me, my lord, that is, my lord, may not be a ground for dismissal of my issue of compassion. My lord, because, my lord, in that case, my lord, your lordship may direct for an inquiry by the authorities whether he lives with me or takes care of me, my mother.
It is your case, you have to prove.
Yes,
Mr.
my lord,
Lady.
whether my brother stays with me or stays with his wife separately, it's very difficult for me to ascertain on record.
You are now shifting the onus.
No, my lord.
That I have a son, he is not result, let them find out.
No, because, my lord, in an identical matter, this sort of direction was passed by another division bench that to ascertain the penury of the family.
Exactly.
Exactly. To ascertain by the authority whether, and a report to be filed whether.
What they have stated is not wrong.
No,
They
no,
have
they have not.
stated that son is
Yes.
a employee.
Yes.
Now you are saying that yes, my son is an employee.
Yes.
But he is not residing with me.
And does not
He's
take
not
care of me.
taking care of me.
Yes, my lord.
Where have you stated that in your writ petition?
No, my lord, read petition, it is
Not
not
the
there, but
Kuta
it, the, my lord, the annexure, my lord, it is there, but it is on record.
Annexure is the representation submitted after the rejection.
No, because there is no scope for me to write this in my prescribed,
certainly it
no,
is
prescribed pro forma. There is no scope for me to write that.
Who said?
I had to write in the prescribed pro
So
forma.
you could have said it in the writ petition.
Only one thing I can show to your lordship. There is one thing I can show to your lordship. In the prescribed pro forma, my lord, if your lordship kindly takes page 40 for once, this is a declaration.
Page 40.
Yes, my lord, this is. My lord, kindly see, I, Srimati Shondha Tiwari, wife such and such, beg to inform you that I have applied for consideration of appointment on compassion ground in Group C.
This is a wrong declaration you give. Whether any dependent of the
Family is employed or not, if so, because my lord, whether any dependent of the family, the son is not dependent of the family. I, with my daughter, are dependent of the family. That is why I've mentioned.
Upon the death of the father, who becomes dependent?
Those
the sons and the daughters become dependent.
Mother, widow, son. Yes.
Could have written one note there that my son, though employed, is not residing with
My
me.
lord, whether any dependent of the family is employed or not. So he is not a dependent. He is earning with the West Bengal police. So he is not a dependent, that I have declared.
Read the next line.
Yes. Whether other dependent of the family member has been employed on compassionate ground in the railway or other organization, if so detail thereof. No, he is not engaged in compassionate ground with the police. It is in his own capacity he got the appointment. So, my lord, in record, I have declared it. My lord, I have declared it, my lord.
Just
And the judgment, if your lordship so pleases, I have the judgment.
No, there is no dispute as regards that.
only my lord, one thing to submit. Son is also residing with the minor.
Where do we
That is
find
there, page 38, my lord. It is the declaration of mother, my lord. Page 38, my lord. Particulars of all dependent family members of railway servant, if same are employed, their income and whether they are living together or separately. My lord, 1, 2, son, my lord, kindly see the same address, 1 and 2.
Yes, the address.
One is the mother,
Where you are reading, Mr. Ghosh?
my lord, page 38, my lord.
38.
Serial number 2.
Same address,
Serial
my
number
lord,
2.
village Dabia, post office Narayanpur, districts, my lord, Jamtara.
Shondha Tiwari was the applicant, wife, widow.
Wife. And number 2, Topon Theory is the son, who is, my lord, working as an ASI of the West Bengal Police. And not only that, my lord, but page 40, mother declared that no one was employed in anywhere, my lord.
No. On
That is,
compassionate ground.
No dependent was.
Dependent on compassionate ground.
anyhow, my lord, the son is also residing there.
The present appeal has
And
been
only one thing to reply to that, my lord. It is the address which is given. The son may have his address in that house. He may reside otherwise.
You have tried your best, Mr.
You have tried to.
I'm grateful to your lord.
The present appeal has been visible.
Can there be any ascertainment of this fact by filing a report by them? Kindly, my lord.
Now we
Kindly.
better case, Mr. Lai.
Compassion I'm praying before your lordship. If it can be ascertained.
Uh-huh.
If it can be ascertained with a report before your lordship, whether he stays with us. Kindly, my lord. My instruction he does not.
Appeal has been preferred challenging an order dated 12th of January 2021, passed by the learned single judge in a writ petition. In a writ petition being WPA 11283 of 20. The subject matter of challenge in the writ petition was an order dated 8th of September 2020. Was an order dated 8th of September 2020, by which the writ petitioners claim for writ petitioner's claim for no, writ petitioner's application for grant of compassionate appointment to her married daughter was turned down by the authorities. Stop. Mr. Lahiri, learned advocate appearing for the petitioner submits that the petitioner's husband was suffering from the dreaded disease of cancer, to which he ultimately succumbed. On 19th of November 2019, leaving behind the petitioner, his one son and two married daughters. Stop. One of the daughters, though married, was residing along with her husband in her paternal house and was totally dependent upon the deceased's income. Mr. Lahiri submits that the petitioner's prayer for compassionate appointment was turned down primarily on the ground that the petitioner's daughter was married. Was primarily on the ground that the petitioner has availed the terminal benefits of her deceased husband. Stop. According to him,
Petitioner is the daughter.
Solely on the said ground, the petitioner's claim could not have been rejected, and in support of such contention, he has drawn our attention to the relevant rules towards grant of compassionate appointment as annexed at page 50, na? 50, na?
50. My lord, the petitioner is the daughter, not the wife. Petitioner is the daughter.
Oh, the petitioner is the married daughter.
Yes.
Sorry.
Joyshri Tiwari is the daughter of the deceased.
তাহলে ওটা চেঞ্জ করতে হবে না the subject matter of challenge in the writ petition was an order dated at by which the petitioner's claim for compassionate appointment was turned down. Right? Stop. Mr. Lahiri, learned advocate appearing for the petitioner submits that the petitioner's father was suffering from the dreaded disease of cancer, to which he ultimately succumbed on 19th of November 2008. Stop. The petitioner was totally though married, was totally dependent upon the deceased income, since she, along with her unemployed husband, was residing along with the deceased. Stop. As such, the petitioner's mother submitted an application in the prescribed pro forma for grant of compassionate appointment in favor of the petitioner. Huh? That is
Yes.
that is
And my lord, the petitioner also submitted. In both ways, submitted. Not only the mother, petitioner
Stop.
also submitted.
The petitioner also submitted an application along with the same.
Yes.
The petitioner also submitted an application for consideration of her claim for compassionate appointment. Stop. Mr. Lahiri argues that the order impugned would reveal that the petitioner's claim was primarily rejected on the ground that the family was not suffering from any financial stringency, as as the deceased widow had received a substantial amount towards terminal benefits of the deceased. Stop. According to Mr. Lahiri, the same cannot be a ground for rejection of the claim of the petitioner. Stop. Such rejection has thus been stop. The ordered impugned also suffers from next paragraph. Drawing our in support of such contention, our attention has been drawn to the recruitment rules pertaining to compassionate appointment as annexed at page 50 of the writ petition
Application.
of the stay application. As regards the ground that the deceased son is already employed, Mr. Lahiri submits that such fact has not been suppressed by the petitioner. Stop. However, the petitioners, however, the deceased son of the petitioner was not residing along with the other family, was not residing with his mother. And he does not look after the needs of the petitioner. In view thereof, the family was suffering from extreme financial hardship. Stop. Such fact has not been taken into consideration while rejecting the petitioner's claim. Stop. Per contra, Mr. Ghosh learned advocate. These are the 2 points.
Yes.
Per contra, Mr. Ghosh learned advocate appearing for the respondents submits that the petitioner's claim was not rejected solely on the ground that the petitioner's widow had received the terminal benefits. Stop. The rules towards compassionate appointment clearly specify that an application for compassionate appointment cannot be denied or deferred, quote unquote, only on the ground that settlement dues of the employee, only on the ground that no. Is to be redeemed from লিখলে আগের লাইনটা দাও না ওটা দেওয়ার দরকার নেই স্টপ স্টপ আচ্ছা ওই মিস্টার লাহিরি যেখানে আর্গু করেছে না সেখানে আরেকটা প্যারাগ্রাফ দিয়ে দাও Mr. Lahiri further argues that the specific issues as argued by the petitioner were glossed over and no finding was returned on the said issues, and as such the order impugned in the present appeal is not sustainable in law. Next, are the learned advocates and consider the materials on record. A perusal of the order impugned would reveal that the learned single judge rejected the petitioner's claim, placing reliance upon the judgment delivered in the case of State Bank of India and others versus Surjo Narayan Tripathi, reported in 2014 volume 15 SCC 739. Stop. The learned judge further observed that the petitioner, who was without employment or support in the family, Placing the learned judge further, took into consideration the fact that the petitioner was the fact that the deceased son is already in government employment. আরেকটা কি point করছিল? ওই মিস্টার ঘোষের জায়গায় আরেকটা প্যারাগ্রাফ দিয়ে দেবে। Drawing our attention to the document annexed as page 38 of the stay application. Mr. Ghosh disputes the fact that the petitioner's son is not residing with the petitioner's widow and other family members. Drawing our attention to the document, to the petitioner's, এটা petitioner declaration.
application for compensation.
জয়শ্রী তেওয়ারিটাকে
জয়শ্রী তেওয়ারি যে applicant করেছে married daughter.
Drawing our attention to a declaration of the petitioner, Mr. Ghosh submits, annexed at page 38 of the petition. Mr. Ghosh submits that the petitioner's brother, who is employed, is residing along with other family members in the same residence.
With the
Residing along with his mother, in the same premises. Single judge which stop. Indisputable stop. Next paragraph. The object of compassionate appointment is to protect the dependents of the deceased and to mitigate the hardship of the family members.
May I take leave of your lordship?
And the family members, and to mitigate the hardship of the family members of the deceased. Stop. The order impugned in the writ petition reveals that the petitioner's prayer was turned down not on the sole ground that settlement dues, that terminal benefits were received by the widow. The order specifies that the petitioner's father expired about 13 months prior to normal superannuation, and that his widow received the terminal benefits. Stop. She was also having her own home, her own house, and her son.
and drawing a lump sum amount of monthly pension.
Settlement terminal benefit বলেছি। terminal benefit and কি লিখলেন? Her own house, her son was also in government employment. In the said conspectus, the petitioner's claim was rejected. In the said conspectus, the petitioner's claim was rejected. Stop. The rules upon which Mr. Lyrie has placed reliance তুমি ওই প্যারাটা কি বললে? না এই যেটা লাস্ট কন্টিনিউ করছে না ওটা ছেড়ে দাও। It was rejected on the ground of such and such use. Stop. In the said conspectus, the competent authority found that the petitioner had failed to establish that the family was not in a position to survive due to the loss of the petitioner's father. Stop. Stop. Upon considering the facts, আরেকটা প্যারা দিয়ে দিও। In the writ petition, there is also no specific pleading as regards the date on which the petitioner's brother got employment, and as to whether he's living in a separate, he's living at a separate place, and is at a separate place. Stop. In the upon considering all the facts, the learned single judge arrived at specific findings, and we do not find any error, and we do not find any error in the same. Accordingly, no interference is called for in the present appeal. Stop. The appeal being such and such and the connected application being such and such are dismissed. There shall, however, be no order as to cause urgent certified. Yes, next.
Good. But under the compelling circumstances. But under compelling circumstances, on behalf of the petitioner, I am beseeching your lordship to take up the matter next Wednesday, subject to my lord's kind sanction.
We say it will not be next Wednesday, it will come back in its turn. Yes, next.
Your Lordship, meantime, if directions may be issued, I'm for Union of India, Your Lordship. It's a 2021 matter. Thereafter,
The can one.
Can one is the application for beseeching your lordship to consider some of the documents which have been annexed in the application.
Not a stay application.
It is actually, in fact, we are not praying for any interim order at the present moment. It cannot be prayed now.
meantime, he could serve a copy upon me, Your Lordship.
Copy of what?
The memo and the can, Your Lordship.
You have not served.
No, memorandum of appeal has not been served. In the appellate side, normally we serve the application only if it is allowed and admitted. Thereafter, the memorandum of appeal goes with the paper book.
Was there any direction for paper book?
No. It is the first time my lord will be considering. This is the first time. It roamed from one court to other, could not be heard by any of the previous honorable judges on the earlier occasion.
File the file. Bloody. Compassionate appointment. Compassionate appointment.
No. My lord, in a precarious situation, a seaman was given to, informed that he died, but the reason of such death was not ascertained. Someone said that the reason cannot be ascertained. Someone said that he jumped from the on board, and during the night time, because of the darkness, nothing could be investigated. So there are various reasons.
What was your writ petition about?
Writ petition about the reason to find out the death and also for getting compensation.
Compensation.
And for quite long years, it is almost 57 years from now, this matter could not be heard out and decided as yet. So an appeal has been preferred out of the order that was
2018 writ petition was of 2018.
Yes.
And it was rejected by a judgment dated.
Yes.
Huh? 2018. Huh?
No, Maraga is 1966.
66 the
Yes.
person.
66 Maraga.
And
Yes.
2018 is the judgment impugned. You preferred the appeal, you filed the application in 2022. What remains in the matter?
But if I am candid to your lordship, it is the appellant petitioner's desire that your lordship should come to some decision. Because the litigant is not happy with the decision arrived at by the learned single judge.
On what ground you tell us that you are not ready today?
No, some of the cost papers, I found that yesterday it was missing from my cost papers. I tried to contact the litigant yesterday night itself, but because of some tower problem, in spite of this morning, I could not get in touch with him. I apprehend that some of the papers have been taken by him.
Petition, in the writ petition, any pleadings were exchanged, any evidence?
No, some of the documents,
The affidavits were filed or not?
in this matter,
Writ petition.
writ petition, yes, that there was filed.
Whereas those affidavits?
Those are with the writ petition. That record has to be brought before your lordship. No, no.
In the record,
No,
you should enclose.
no.
Stay application finished.
Actually, in writ petition, we normally do not take those steps. Those steps are taken in the case of tribunal matters.
No paper book required, we will hear and dispose it.
Subject to my lord's kind choice.
In records reveal that in connection with the appeal, an application being Can 1 of 22 has been filed. Stop. The appellant is directed to serve a copy of the said application. You are for all the respondents. Upon the learned advocate representing the respondents within a week from date, application you served?
Yes, application has been served by post.
Your lordship, another copy maybe because it was served in ministry, your lordship. Somehow it has not, only the case number it could be given to us.
The appellant is directed to serve a copy of the said application upon the learned advocate who has entered appearance for all the respondents. Within a week from date, establish the matter for further consideration in the combined monthly list of September 2023.
Obliged.
Yes, next.
Lordship, Mr. Kotik Chandra Das is appearing for the appellant Lordship in this matter. He is not present today, Lordship. I am praying for not today on his behalf.
I am for the respondents union of India.
Not today, it will come in its turn, Mr. Mishra. Yes, next.
My lord, I am appearing for the Union of India.
Lordship, I appear for the appellant in this matter, your lordship, led by Mr. Pradyumna Sinha. Due to your lordship fever, he's not in court, your lordship, today. If it can kindly be taken up next week.
Will come in its turn. Next, yes, 180.
I am praying for only not today, your lordship.
What is the application about, Mr. Singh?
The application, my lord, that is, my lord, in connection with an appeal and
Appearing in this matter, he is not come to court, your
is
lordship.
praying for some interim relief. But my lord, in fact,
For inclusion. Why you people mention unnecessarily the
Lordship, but due to some personal difficulties,
when the matter is taken up, every advocate has difficulty. See, everyone has difficulty.
well, in terms of the last
not today,
order
your lordship.
passed on 10th of March 2022, now, my lord, it fell from the earlier division bench that the matter be heard, appeal be heard, subject to, my lord, a direction upon the respondent CSTC for whom I appear, that place the certain documents, subsequent development by of an affidavit, those documents. Those affidavits are ready, and my lord, copy also served. The affidavits are there, that containing that the departmental proceeding already come to an end. And the appeal has become infectious. This was our contention. If you will also allow me, I can file it, my lord, today.
Who is your senior?
And advocate Joy Chakraborty, your lordship. Learned advocate Joy Chakraborty.
Joy Chakraborty. Yes. Read petition. When was that earlier division bench order passed?
My lord, the order is of dated 10th of March 2022.
10th of February. এই যে
10th of March.
দেখেছে, চলে গেছে 19 submitted in terms of honor disciplinary inquiry as detected concluded. Infractuous হয়ে গেছে। when was it concluded?
My lord, concluded, my lord, in the midst of the order passed by the learned single judge, that within a certain specific period to be concluded, and that was possibly 5 weeks. And within that period, my lord, departmental proceeding came to an end. And my lord,
It was terminated.
no, it is not a case of termination.
What was the punishment imposed?
My lord,
এইখানে থাকবে না
ওর affidavit টা পাবে।
থাকবে না পরেরটা
Give your affidavit.
well, this is the affidavit, lordship, and it has been annexed here too.
দেখি দাও দেখি। You have given a copy to your friend?
Yes, copy, sir, lordship. My lord, findings of the departmental proceedings, my lord, the disciplinary authority is at page 33 of the
Now, what had been the fate?
page 33 of the affidavit that my supplementary affidavit which I file here and now, my lord, page 33. He has been retained in employment.
reduction of pay,
Penalty is a reduction of pay to the initial stage in the scale of pay of the conductor, because his status was and still is conductor in the transport corporation. Unauthorized absence for Malad the more than 2 or 3 years. And period of absence shall be treated as dies non.
Dies non.
No, yes. So for the period of absence.
Dies non টা তুলে দিয়ে করে দিবেন। Dies non to discontinuance হয়ে যাবে। কিছুই পাবে না। Yes, sir, you have to prefer a fresh repetition challenging this order.
Kindly make it,
Appeal becomes infructuous, na?
kindly make it not only not today, your lordship.
Mr. Sen learned. Mr. Sen. Senior. Signature টা জেনে নিবা।
সার্ভিস হয়েছে বাবা। এই যে দিলাম একটু
Mr. Sen,
লিখে
senior government attorney কি জেনে নিও একটু।
দিয়েছিস ওই
Hearing
উপর
for the respondent submits that during pendency of the present appeal,
মাইল
the final order in the disciplinary proceeding has already been passed, and as such, the present appeal has become
infructuous.
Stop. Stop.
And in support of this, my lord, the relevant documents have been filed by your affidavit.
In support of such contention, in support of, he has placed reliance upon the documents annexed to the supplementary affidavit.
এই যে 4-5 পেজ।
হ্যাঁ, বলছি। কি লিখলে, has become infructuous. Stop. Let the supplementary affidavit as filed by Mr. Sen be kept on record. Stop. Today, however, an adjournment has been prayed for on behalf of the appellant. So you're given a copy to him?
My lord, already, yes, my lord, on 4th of May 2020.
বললেন,
Long back.
Mr. Sen? না না, তার আগেরটা Mr. Sen files এ simply ওটা লিখবে না, ওটা কেটে দাও। তারপরে বললাম না Mr. Sen, হ্যাঁ, তারপরে লিখে দাও ওই let the supplementary affidavit, as filed by Mr. Sen be kept on record. Stop. A copy of the same has already been served upon the appellant. Stop. Today, however, an adjournment has been prayed for on behalf of the appellant. Stop. In view thereof, list the matter under the heading to be mentioned. Under the heading to be mentioned. Tell us when will your signature
tomorrow করো না আসতে পারবে না যদি হয়
is the matter under heading to be mentioned in the daily supplementary list of this court on আজকে কত তারিখ?
16
on 22nd August.
Mike.
All right.
Mike.
Come on 22nd to be mentioned. Yes. এই ওর নামটা নিয়ে নাও, নামটা নিয়ে নি 181. Yes. Nobody here. Not today করে দাও.
In this matter, I am appearing on behalf of the respondent.
Lordship, I am for the appealant in this matter. I am led by Mr. S.S. Arifin. My senior is busy on another courtroom number 18. I'm praying for a short passover.
What is this matter? What is this matter? You are Mr. Arifin's junior. Yes. You place the case.
I don't have any knowledge about this matter.
We are with you. If we are with you, you have problems. Then place the case. देखिए file to the. If we intend to pass any contrary order against you, we will adjourn the matter. All right. Yes.
My lord, if your lordship kindly take it to tomorrow.
আবার কি tomorrow? Well, let him argue. You have read the brief?
No.
How long you are here?
This brief I have not read.
No, you have joined the practice when?
2016.
16. Then you are quite senior. Acha, show us the order which has been passed, which you have challenged.
Lordship, page number 43.
इंद्रजीत सिंह देते हैं
Unsuccessful candidate কি করব? Yes, why did you prepare a revised list?
My lord, I am without brief today. Kindly take it tomorrow.
tomorrow.
সেটা আপনি বলুন।
আমার 83 নম্বর ও কিন্তু 131
তারপরে এটা পড়ো কোথায় আনসাকসেসফুল তো ডিভাইস মেরিট লিস্টে বসে রয়েছে এখন ওকে নিচ্ছে না যেহেতু ভ্যাকেন্সি you take instruction that you prepared a revised list and in the revised list you included him at 131 and took a plea that there were only 88 vacancies. Then the remaining vacancies have to be considered in the subsequent selection process. What has happened? He was not unsuccessful.
You should allow me some time for taking instruction, your lordship.
Next monthly list.
Much obliged. Grateful, Lordship.
You obtain instruction and come. Why the revised list was preferred? Yes, next. Yes, who is there? 183?
183.
You are there, Mr. Sen.
My-
You are there.
I appeared for the state respondent. Mr. Oyon Banerjee, my lord, is appearing for the appellant. এটাই তো।
Next.
No, my lord, the only thing, my lord, he is not here. But my lord, Mr. Banerjee, on behalf of the appellant, my lord, filed a supplementary affidavit on the last occasion when the matter was last called on. And now, my lord, on that day, my lord, I obtained, my lord, leave to file one supplementary affidavit as exception to that on behalf of the, my lord, the district.
They filed to the.
Now, my lord,
When was that order passed?
my lord, that last order was passed. Supplementary affidavit to be filed by the appellant on 27th of June. And my lord, last order passed 17th of August 2022. No, my last order passed on 17th August, and then time to file that exception was extended in December 2022.
Till now, you have not filed that.
No, it is ready. After that, my lord, there was no scope. The matter did not appear, my lord.
3 weeks after
Because
reopening of winter
affidavit-
vacation of 2020.
My lord, affidavit was exception to that affidavit. It was affirmed on, my lord, February 2023. It has been affirmed on February 2023 by my lord, district social welfare officer.
No one appears today on behalf of the appellant. Mr. Sen, learned additional government leader appearing for the state. Files
My lord, the supplementary affidavit in terms of the earlier order.
exception.
Annexing certain documents,
It is an exception, na?
exception to the
দেখি
supplementary.
দাও ওটা। Files an exception to the supplementary affidavit filed by the appellant. Let the same be kept on record.
Filed by the respondent.
Is the matter for further consideration in the combined monthly list of September 2020.
September 2020. Monthly list. Monthly list.
Writ petition is still pending.
In fact, my lord,
Interim order চেয়েছি।
there is no scope for any interim order, but in any event, my appellant is not here. Very short point is involved with regard to, my lord, the temporary engagement as child protection officer. Because the observation and the findings of the learned single judge was that a person against whom, my lord, the allegation of POCSO Act and other charges are there. And my lord, the one after another, my lord, FIR for 2 back-to-back incidents. So that contractual engagement as a child protection officer, there is no reason to continue. And in fact, discontinuation of that temporary engagement, that is the subject matter of the writ petition.
You discontinued the temporary.
Yes, we have discontinued because the, my lord,
Now, what is the state of the criminal proceeding?
that is pending, and my lord, that is why, my lord, the supplementary affidavit I was
What is
asked to
the
file.
work of a child protection worker. Child protection worker allegation is POCSO.
Yes, child and also
Protection হয়েছে তাকেই POCSO। আর কি protection?
and there are several other allegations also, my lord, because when the district judge, my lord, entrusted him to take care of a child,
Allegation is.
allegation is that, so for that matter is concerned, allegation is that
No, no.
he allowed him,
Affidavit লিখেছেন স্যার।
না না এরপরে এই যে পার্সিয়ালিটি
হ্যাঁ সেটাই।
এটাই
হ্যাঁ, ওটা
in that case, allegation was that he allowed him as a child protection officer, my lord, outside the state, my lord,
to, my lord, engage in certain work in a factory or elsewhere. And then, my lord, he was asked, then he said he was not, the child is not with me. And then on the next day produced, and that was the another case against him. And the district judge, my lord, observed this.
Supplementary evidence affirmed filed for a legal two-word filed. The supplementary affidavit affirmed. Same be kept on record. Yes, next.
September monthly list, lordship.
But I appear on behalf of the appellant.
I am for the respond number 3 to 5, West Bengal State Legal Service Authority.
I am for the state.
On the last occasion and the order was passed.
Yes, Mr.
Last occasion, my lords was pleased to pass an order which on 7th of June 2023. This is an appeal, my lord, arising out of an order dated 11th of April 2022. Now, my lord, under the particular, my lord, Legal Services Authorities Act 1987, my lord, under section 28(1), my lord, there is a power of the state government to take action in consultation with the Honorable Chief Justice and, my lord, by a notification to frame to carry out the rules. My lord, I have brought to my lord copies for my lords.
So what is the stay application for?
My lord, stay application is, my lord, nothing, my lord, but to hear out the appeal, my lord. The appeal can be disposed of within a second. Why I say this? Because lordship may kindly consider the order passed. Otherwise, my lord, there will be no useful purpose in keeping the appeal pending. Kindly see the order.
And you will have to unnecessarily appear for further occasion. There's no necessary. Add that rider.
I cannot say that. I cannot say any comment. I cannot make a comment.
Yes.
I cannot make a comment. Kindly see, my lord, the order, my lord, which was
Don't
passed.
make a comment, then let us go through the order. We
Yes,
will not
yes,
hear you.
11th of April 2022. This is the order against prisoner.
Tell us, you have said 1 second, you have already taken 2 minutes.
That's I am just indicating to my lords.
See what you are indicating.
My lord, there
We want
was.
to hear you, we are not seeing the request. Tell us what is the story.
My lord, we are the members of the State Legal Services Authority. Now, my lord, a representation was filed. This representation was filed praying for absorption of service as a regular cadre. Now, my lord, a writ petition was filed and, my lord, a learned single judge directed the Secretary of the Judicial Department to pass a reasoned order and to communicate the same to the order. Now, the reasoned order which was passed, which was the subject matter of challenge, my lord, kindly see, my lord, page 59 to 62. Page 59 to 62 of this stay application.
So against challenging that you prefer.
My lord, my lord, after that, we a particular, yes, my lord, I say yes. To page 50, kindly see page 59 to 62.
59 to 60. Yes, the order was passed.
Yes, this order now, my lord, kindly come to the operative portion of the order. It starts from page 61. After going through the portion.
After going through the facts and circumstances of the case, I am of the view that the yes, Miller. I'm sorry, Miller.
Page 61. Last page, huh? Right. Dangerous. বন্ধু ছিল কি বলছে জাস্ট বলছে
Yes. After going through the facts and circumstances of the case, I am of the view that the writ petitioners are qualified candidates. They have secured their position through examination for recruitment. They claim for granting regular pay scale at par with the state government employees. But as the aforesaid notification number 23/8/2013 contains a specific point that such engagement will not be regularized in future in any manner whatsoever, it is not possible for me to grant the prayer of the writ petitioners without concurrence of the finance department at this juncture. It further appears to me that as the conditions of service of the employees of SLSA, DLSA, and SDLSC and ACLSC are governed by Legal Services Authority Act 1987 and the rules and the regulations made thereunder, provisions of the West Bengal Regulation of Recruitment in State Government Establishment and Establishment of Public Undertakings, Statutory Bodies, Government Companies, and Local Authorities Act 1999 are not applicable in this matter. It has been stated earlier that the existing WBLSSA rules 1994 already contain certain provisions like number of employees, their conditions of service, pay and service of the employees of SLSA, DLSA, SDLSC, ACLSC. In terms of Rule 6, 9, 11, 12, and 14 and 19 of the aforesaid rules, the specification of the post with scales of pay may be incorporated in the schedule to the rules. Recruitment rules of all posts is required to be made for recruitment to the vacant post of SDLSC, DLSA, SDLSC, and ACLSC. In the recruitment rules, a provision may be incorporated in line of Rule 8 of the Calcutta High Court Computer Technical Manpower for District Courts Recruitment Rules 2014 as enabling provision for absorption or regularization of the existing contractual employees of the SDLSC. I accordingly direct my office to submit draft amendment rules. Now, Millard, after this order was passed, a draft amendment rules was framed. Now that my lords may kindly consider that was framed in terms of a letter dated 10/8/2021, page 64. Next page 64. Now this draft amendment rules was framed and Millard, this was communicated. Then Millard, after this Millard, my lords may kindly consider that the on 3rd of September 2021, the draft amendment rules was modified and a request was made to offer views of the modified draft amendment rules.
Is full at page 64.
Millard, I have shown to my lords page 64 to 74 is the Millard, yes. I'm sorry, Millard, page 64 to 74. Millard?
Published in Extraordinary Gazette in 1994.
Yes.
When was this amendment made?
Now, Millard, kindly see the date of this letter. This is 10th of August 2021, subject to correction of my lords.
Page 63.
Page 63, yes.
How this can be kindly come to 64?
Page 64. This is a notification, Millard. It is a particular, Millard. Kindly see at the top. Kolkata, the August 20, Millard, the date has not been given, August 2021.
I am directed, page 63 says, I am directed to send herewith a copy of draft West Bengal Legal Services Amendment
Rules 2021. Yes.
Page 64 is notification is of 94.
Miller, this is 2021, subject to correction of minor. First line, yes.
At the top.
First line, yes.
Notification, then Miller, kindly see at page 64.
Plus 2021.
Yes, yes. August 2021.
These rules are amendments.
Then what happened?
Then Miller, after this letter was issued, my lords may kindly come to page 74. This is the all the Miller particular provisions. Kindly see page 74. Miller, these draft amendment rules, this was modified. And Miller, I stand wrong, Miller. This was modified with a request, Miller, to offer views for the modified draft rules. Kindly see the contents of the letter. In inviting a reference to this department numbers, department letter number such dated 10th of August 2021 on the subject noted above, I am to say that the draft amendment rules has been slightly modified. I am sending herewith a copy of the modified draft West Bengal Legal Services Authority Amendment Rules 2021. I am to request to offer your views in this matter at an early date for taking necessary action. This letter was issued on 3rd of September 2021 to offer views. And this offer of the views, Miller, this was sought from by the Principal Secretary to the Judicial Department to the member secretary SLS. Now, Miller, your lordship may kindly consider, your lordship may kindly come to Miller, the particular Miller order of this Miller 11th of April, Miller. Page Miller 84. Kindly see this. After this order was passed on 3rd of September 2021.
You expressed your views.
Yes. Kindly see, Miller, the court, Miller, we had filed a writ petition. Then Miller, it appears Miller, a learned single judge Miller had directed that that Miller liberty is given to the petitioners to challenge the rules after the proposed amendments are Miller are made. Now, Miller, I am only aggrieved with the particular action of not fixing an outer time limit. Whatever let them do, they may Miller pass Miller and a particular Miller a rule in my favor or against me, but Miller, there has to be an outer time limit, and that Miller, I want to show to my lords, Miller, section 28, subsection 1 of the.
Kindly page 85, please read that.
The page 85, Miller, is this order.
Principal Secretary, page 85, second para has
Yes.
disposed of the representation by orders.
By to challenge the rules after the proposed amendments are yes.
Further amendments, draft rules have not yet been finalized. Basis of draft. Can I request?
And this was also not the scope of the writ petition. Kindly see the scope of the writ petition. Yes, I'm sorry, Milord.
What is your grievance?
My only grievance is whatever they want to do, let them publish a rule, whatever they want. But Milord, kindly give Milord, these are the particular employees working in different courts in our high court in the
That is a cause of action for a fresh writ petition.
No, I say, Miller, kindly consider this is a continuing action. Why I am saying this? Because your lordship may kindly consider my writ petition. I just leave it to my lord because kindly see page 47.
Premature, right? First order.
বলতে দিক আমাকে বলতে দিক I am for the legal service authority. Legal service authority.
Why it is not being
It is not within our domain. Your lordship, may I submit? That matter can be clarified, yes. Because the subsection 1 of section 28 specified that it is within the domain of the state in consultation with the Honorable Chief Justice, the rule has to be framed.
I have
We
handed
have
over
got
the-
no power
Yes.
to express our view.
Rule was framed, but it was not finalized. Before finalization, government think it fit to sort of for opinion from the legal services authority, because petitioners are the employee of the legal service authority. But twice we sent it to the legal services authority for their opinion, but we have not yet received any opinion from them. But immediately after receiving their opinion, we shall finalize it, and then after consultation with
Kindly
the
specify your time limit. That's it.
High Court administration, we shall publish it before the official gazette.
They have not given any,
Yes.
any feedback. But we approach the Chief
Right.
Justice.
But if your lordship passed that order to that effect,
The law is very much clear.
You have
Bef-
sought for objection to the draft amendment.
yes, my lord.
That you have written to them in 3rd September 2020.
Yes, 21.
Now suppose if they do not reply to this, what you are to do? If they do not reply to this, you cannot indefinitely wait that it is not.
Yes.
up. If they do not give any suggestion.
Well, let me take instruction to that effect, my lord.
In the statute, there is no provisions.
Are taken from whom?
Miller, that has been indicated
28(1).
in section 28,
One,
subsection 1.
Subsection 1. It is very much crystal clear, lordship. Legal authority has got no authority to express their view as per the statute.
Understood your step. Okay.
Mr. Bhattacharya, you don't have any problem with the draft rules. Do you have any?
No, we are saying whatever you want to do, but take something, do as my lords was pleased to indicate.
File a short affidavit.
That can it be left in the domain of
So far
uncertainty?
the affidavit, we will do, sitting will abide by that.
Either of these things. One, you are saying that I am not required to respond to that.
Because the statute provide, lordship, as per statute.
Record your submission, then you cannot do anything about these draft rules.
But kindly record that. Kindly record that, because as per the statutory provisions, it is to be within the domain of the state government in consultation with the Chief Justice. It is to be finalized, lordship.
Your contention is that I am not required to give any comment as regards.
Lordship, lordship,
Because the legislation does not confer any authority upon me to.
Lordship.
This is your contention.
this,
So if that is your contention, then have you written a letter to the government?
but that has not been
No
done.
response.
That has not been done. But
So Mr. You tell your officer that they are not wanting to give any consult with the Chief Justice.
yes,
Tell us a time.
yes,
Let-
yes,
Let them supply their view by either by a letter or by way of affidavit, my lord.
No, they are saying we are not required to give any.
but kindly record my submissions on that.
Will record that submission. So once it is recorded, you will proceed in terms of Rule 20.
Very well, but kindly record it and keep it on the next date. I shall come with a definite instruction from the state government regarding this issue, my lord. Kindly, my lord, on the next.
Lord, I
date, my
say, Miller, that will delay the entire thing, Miller. This has been
lord.
delayed.
This is the
Just
this is
leave
the
it to my-
factual
I
position.
say, I leave it to my lords.
Mr. Bhattacharya, we cannot settle any time limit for the legislature.
Just an outer time limit, outer time limit. But why I'm saying, because Millard, kindly see, Millard, the particular, Millard, the,
The body,
I'm sorry, I'm sorry, I'm sorry.
and you give an instruction that within 6 months you will finish. We will keep that instruction
well.
of yours on record.
Very well.
This is good.
My lord. Kindly pass an order to that effect, my lord. For instruction from the authority, my lord.
একদম ঠিক আছে। না, 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 ঠিক আছে। কোনো আর নয় কোর্টে এসে ফাইনাল করতে পারে। এটা তোর বুটি।
Dr. Sarda, you come with a letter to us that you need not respond to this. You have no views as regards.
Lordship.
Only come.
My lordship, can you record that? No, lordship.
Get problems subsequently, huh? Because on the
Because lordship kindly appreciate the situation.
we have appreciated. We are not calling for evidence. Your contention is you are not required to respond.
As per the provision of the law.
Come with a letter to that effect.
It's the instruction of the authority before the signatures. This is the registered authority with the signature. That's the point.
A statutory authority cannot go beyond the statute.
তোর একটা চিঠি দেখবি সিঙ্গেল জাজের ঘরে দিয়েছিল। তো তুই এটা দেখে নে একবার, তাড়াতাড়ি দেখে নে।
এটা দিয়ে দিত না?
হ্যাঁ, দিয়ে দিবি।
হ্যাঁ, হ্যাঁ, এটা দিয়ে দিত।
তুই দিয়ে দে, তুই এটা দে।
এটাকে দিয়ে দেবো ওদেরকে না জিজ্ঞেস করে?
সই করা নেই।
সই করা নেই, সিগনেচার।
সিঙ্গেল জাজে দিয়েছিল।
না না, সিঙ্গেল জাজে দিয়েছে, সই করা নেই।
ইমেল মেলে দিয়েছিল থ্রু মেল। থ্রু মেল।
मैं I have been may I submit? Just now I have been grateful to my learned friend. Just now it has been handed over to me. It appears that through mail in the before the first honorable court, a letter has been given where it has been specified that the may I place it because I have a one copy that
This is an email communication.
email communication. The legal and section 21(1) provide the state government in consultation with the Chief Justice of the High Court may by notification make rules to carry out the provision of this act. And as such, the respondent number 3, that is the Legal Service Authority, to 5, have no obligation to express his opinion as sought for by Judicial Department.
Who has written?
It has been written by the member secretary. Dadin member secretary at that point of time.
It is written to the particular advocates, not any government.
That's why I cannot place it right now. But the statute is because it is very much crystal clear because the statutory authority cannot go beyond the statute.
We are not doing anything beyond the statute. This is absolutely a vague submission.
Principal Secretary has sent the rule and draft rule and amended rule, seeking your views.
What is right or
Now, what is your stand?
my stand is
My Lord Justice Chakraborty asking whether you will respond to that.
we are not responding. As per the provision, we are not responding. We are
Tell them that you have referred it to us, we have no jurisdiction. You should have written it to government.
then Lordship kindly record that.
Mr. Body, strictly speaking, appeal is not pending.
Yes, my lord. That was my submission, my lord. Appeal is not maintained.
That when, as and when final.
Premature.
Yes, yes,
Sufferings has to be mitigated.
yes,
Taking advantage of that.
yes, my lord.
So if you cannot respond, you come with a proper instruction before us. To tell them that they have no views to offer. Now, what is the government stand? We will
Very yes.
dispose of the appeal on
Lord,
the basis of
My
your
lord,
state.
I shall come with that instruction.
Take 8 months, take 6
My lord,
months,
I shall come. My lord, I shall come with that instruction.
and we will dispose of the appeal recording your contention.
That will suffice.
The present appeal has been preferred.
Instruction here.
An order dated
একদম ঠিক আছে
11/4/25 passed in a repetition being WPA 201115 of 2020. Hard Mr. Bhattacharya, senior advocate appearing for Dr. Shahara learned advocate. Dr. Shahara learned advocate appearing for the respondent numbers
3 to 5. 3 to 5.
3 to 5. Yes, give that email. You can record that, Mr.
Can be done because I want to resolve the issue once and for all.
আমাদের কিছু করার নেই যতক্ষণ অবধি জিনিসটা হচ্ছে ততক্ষণ অবধি করতে কিছু ইয়ে করা যায়
Many of the persons will be retiring in the interregnum period. I leave it to the
Shahara learned advocate appearing for the respondent numbers 3 to 5. Submits, upon instruction that the said respondents have no obligation to express its opinion as sought for by the judicial department. The memo dated 3rd of September 2020. And that in terms of section 28(1) of the
Legal Service Authority.
legal service section 28(1)
of the Legal Service Authorities Act, 1987. State government in consultation with the Chief Justice of the High Court may by notification or make rules to carry out the provisions of the Act. In view of next matter, in view of such stand taken by the respondent numbers 2 and 3 to 5, Mr. Badi learned advocate appearing for the state is directed to avail necessary instruction. Mr. Badi, you ask your officer, you specify a time.
and get
Mother.
to my
Say 6 months. Then if you do not do it within 6 months, they would be having an opportunity to file a fresh request. Not at a reasonable period, you kindly.
My lord.
Avail necessary instructions. Stop this matter for further consideration as per orders. Supplement. 14th September. We are giving you 3 weeks. Count
Madam.
the written
My lord.
supplementary list.
My lord, let it be kept. We will need. Lordship has also taken care of myself, that has also safeguarded me. I'm deeply aware.
We have safeguarded all except our. And next day, Mr. Bhattacharya is not required to appear.
I do not appear. I have in fact, I did not want to appear. But Milord, all these staffs of Calcutta High Court, they are chasing against me.
Then
I'm
don't
saying
curse us after going out of the.
Deeply aware.
Yes, next man. Come on then. Come on.
Lordship has to save us.
Yes, 185.
I have for the response.
Yes, who is your other side?
Mr. Nila Sengupta was for the appellant.
We have the determination.
Service matter, service. Group 6, sir.
The application.
Can application was there, that has been allowed. Condonation of delay has been allowed and stay is there.
So now, who stay is there.
Stay is there and
The application disposed of.
no, Lordship. Can application has been disposed of. That is the condonation of delay.
Now the appeal has to be heard. Na?
Yes.
So the papers are on record, or do you intend to file any paper?
A formal direction for formal paper book may be given, Lordship, because
Formal paper.
I am for the respondent, Lordship.
Oh, you are for the
Yes.
case.
I am for the respondents.
Come on the next day. So they get to file the call.
পেপার বুক দিয়েছে বোঝায় নাকি
Ready হয়ে গেছে, না?
সলভ করে নাকি
You have not been given the paper book. Paper book is, I think, ready.
গুলি আছে
No paper book has been, it's the voluminous, is the voluminous thing.
One appears on behalf of the appellants, to Mr. They learned advocate, appearing for the respondent petitioner is rights.
1 and 6, 1 to 6, Lordship. I am the contesting respondent.
So there are many.
Contesting respondent is, Lordship, Garden Shipbuilders. 1 and 2.
1 to 5.
1 and 2, Lordship. 1 and 2. I am the contestant.
Advocate appearing for the respondent numbers 1 and 2 is present. Grant a further opportunity to the applicants to appear on the matter for further consideration in the combined monthly list of September.
September monthly list.
application
I beg to appear for the
186. My lord, it is my application.
I beg to appear for the writ petitioner respondent. Lord, this is a case of dismissal.
My lord, it is my application.
Yes, you will submit. Lord, this is the case of dismissal. Lord, after prolonged hearing by the learned, by the honorable single judge, Lord, there was a judgment. Lord, that order was dismissal was set aside with a direction upon the employer, Lord, to de novo with certain Lord, situation, Lord, and with immediate reinstatement, because in the entire disciplinary proceeding there was no suspension. Questions of payment of money, Lord, will be decided after the de novo proceedings. But till date, Lord, I have not been reinstated. Lord, they have preferred the appeal, and Lord, the honorable single judge, Lord, has passed this judgment solely on two grounds. One ground says that there is a violation of rules, and another is, Lord, there is a violation of natural justice.
My lord, it is my application, if I may.
Lordship, so far the matter is concerned,
This is 186, can 1 and can 2.
my lord,
Can 1?
this is can 3.
What is can 1 then?
My lord, the can 1 was the application for stay.
Yes.
That has not been disposed of, but to that an order had been passed, which my lord will find at page 9 of my application. That is IA number can 1 so and so of 2022.
Disposed of.
And my lord, in this, the operative part of the order, my lord will find on page 11.
What has still asked?
My lord, the order is here. Here it is not clearly mentioned that the matter has been disposed of. Here, let there be a stay of the judgment and order of the Honorable Single Bench till the end of February 2023, or until there.
No,
has
stay
been
has been vacated.
My lord, there has
Stay
been a
has been
stay.
vacated.
No stay has been vacated. Subsequently, the stay had been further extended by another order. My lord will find at page number 13.
Then
You have filed a vacating application.
no, they have filed an application for stay of operation of the interim judgment.
My lord, kindly,
What does it mean?
my lord, kindly allow me. I'll just take 2 minutes. My lord will kindly take up page 13. This order of stay had been further extended till till 3rd of April 2023.
That was also elapsed.
Subsequently, that order had further been extended. The stay had further been extended by an order dated 16/5/2023, which my lord will find at page 15 of my application. My lord will kindly take up page 16. My lord kindly sees can 2 of 2023 stands accordingly disposed of.
So can 2.
Can 2, that was can 2. Can 2 had been filed for extension since the final date was over. I mean, the order of stay was no more operational.
What was the order? D3.
My lord, can 2 of 2023 stands accordingly disposed of. Let the matter next appear under the heading application group 6 in the week beginning 12th June 2023. All parties to act and so. And before that, accordingly, the interim order stands extended till the end of June 2023. Now, my lord will kindly take up my submission made in this application. My lord will kindly see.
So, no interim order today.
I am not protected by the interim order. That is true. But the fact remains that this matter had been mentioned with service to him on 28th June 2023, that is prior to expiration of the order. But subsequently, my lord knows there had been a change of bench and determination, and so many things happened, and the matter never came to list.
Contempt petition.
They have filed a contempt petition, my lord.
Has it been fixed?
My lord, the contempt petition has not yet been taken.
Clear out the main, finished everything goes.
As your lordship pleases, because it's a long matter, and I'm led by senior advocate Mr. Joydeep Kaur in this matter. If your lordship will fix any day, we are ready, my lord.
Yes.
Let there be at least an interim protection.
No question.
Since the interim protection had already been given by a coordinate bench.
Yes, fresh order cannot be passed.
Your interim application, extension application has been disposed of.
My lord, I have filed another interim application, my lord. This is the interim application, my lord.
What is the number of that application?
Can 3.
For granting fresh order.
Can 3, my lord.
For granting fresh interim order.
Can 3 in connection with MAT 918 of 2022.
Yes.
This application has been filed only for the reason since the interim protection was no more with me since the end of June. Subsequently, this has been filed, my lord. Because the matter had already been mentioned on 28th June and the mentioning had been allowed.
All the papers are on record.
Yes.
My lord, paper books have been
ready.
Paperwork
has been ready.
Paper books have been prepared.
Paperwork have been prepared and served. And my lord, the copy was.
Now we fix a date on the supplementary list. We will take up the appeal.
Right.
And we dispose of this application, extending the interim order.
No, the questions of extension, with my respect to submission, does not arise. June, interim order expires. Today we are on August. I have made the application for contempt, but this contempt application, in the contempt application, we have told before the Honorable Single Judge that there is an appeal. There was a stay order. We are not proceeding in the contempt. We are not proceeding in the contempt.
My lord, I have no instruction to that effect because CPAN, my lord will take up paragraph 7. The contempt petition is still pending against me.
Yes, I'm telling you that.
Whatever submission he has made, that is not on record, my lord. That is not on record. These are just affirmance he is making.
And you know, kindly see the prayer of this application 3.
Understand. He
My lord.
now says I will raise an opposition to this. Your matter will be further taken.
Lordship,
He will record his statement that he will not proceed with the contempt.
lordship, as your lordship pleases. As my lord pleases.
And Milord, kindly fix any day, Milord, or Milord. And Milord, if it is possible, Milord, time, Milord, so that Milord, entire matter can be disposed of. Milord, this is a case of dismissal with immediate reinstatement. I was never, Milord, suspended during the disciplinary proceedings. Milord, till date I have not been allowed to join.
Just one point to add. The learned single judge had been pleased to give us the liberty to put him under suspension on reinstatement.
That is dependent because
Subject to
the authority
initiation of the
decide.
proceeding de novo for
Let the
from a
authority
certain
decide.
state. He was
Let
agreed.
the authority decides. But this is a dilatory tactics completely. Milord, one interim order, Milord, they have obtained, Milord, for 1 month. After expiry of that, another application for passing the another order, and Milord, thereafter expires. Then another application. By way of this, Milord, it is going on.
Next Wednesday, it first time. It's only the first matter.
Next Wednesday. I'm grateful to your lordship.
But the application will remain pending. The application will remain pending.
Everything will be completed.
Then ask Mr. Court to appeal.
Lordship, mine. I'm grateful.
I'm grateful to your lordship.
The first matter.